Please.
Item number 40.
40 at page number 172.
Yes.
Lord, your lordship may not reach today,
Hmm.
and from tomorrow I will out of station for a week.
Hmm.
So, my lord, my prayer will be kindly adjourn it till 20.
Till
28th
28th of January.
January. Because, my lord, some other matters I have shown your lordship on the last day.
Hmm.
They are regarding the pensions, freedom fighters' pension.
So who is the other side?
But the other side took time on the last day.
Yes.
It was fixed today in his presence. It's a new motion. So, my lord, let it appear. No interim order is there. Nothing is there. Let it fixed on 28th. My lord, I will be.
Though the matter is fixed as item number 40 in the today's list, but the learned counsel for the petitioner is for fixing the date after 29th, after
28th.
29th, after
Well, instead of
28th of January 2020,
in 29th,
in view of the submission made by the counsel for the petitioner, let the matter appear on 3rd February, 3rd February under the same heading. Item number 40.
32 days list at page 172.
40.
440. May I seek your lordship's
Yes.
indulgence, my lord, to seek leave, my lord. My lord, it's a public meeting.
Ah.
My lord, SDU has orally refused, my lord, to use the, my lord, a ground. My lord, that's my plan, my lord, so that I can conduct this.
When the
20
public meeting?
24th is the meeting date.
24th.
Yes, my lord.
24th is
Friday, Saturday, possibly.
next Saturday.
Next Saturday.
Okay. Serve the copy.
So, I'll serve the copy, my lord, kindly fix it, my lord, and to
So when
twist.
applied for?
My lord, applied for on, my lord, long back, my lord, on
So they have rejected.
29th,
They have
orally, over phone, orally. No formal refusal.
But why
I have mentioned, I pleaded that.
okay.
29th December, I have applied.
Leave granted to affirm the affidavit and the list the matter on 21st January.
Lordship,
As
may,
urgent motion. Urgent motion.
may I permitted to mention your lordship one item for inclusion. The
Hmm.
urgency ground is
What is the urgency?
urgency. The petitioner is a senior citizen
Ah.
and he is deprived her maintenance from her son. Kindly
Maintenance from?
maintenance.
Why you are not gone to the SDO? Why you not file an application under section 4 or 5 before the SDO? Why the court will, what the court will do? Senior citizen.
Senior citizen.
So go, you have act of the maintenance act.
Yeah.
Go through the act, file an application before the SDO. The court will not do anything.
This is a matter, item number 39 of today's list. It was directed to be listed on 28th January. Mistakenly, it has been listed.
Which one?
39.
Item number?
39.
39.
Yes.
It is fixed listed as
On
per the
28.
order is there.
Yes. देखे नहीं देखो
28 then 29340. Though the matter is listed as item number 39, but by an order dated 6th January 2026, this court already fixed the matter on 28th January 2026. Let the matter appear on 28th January 2026 under the same heading.
My lord, may I have your lordships kindly to mention an urgent matter, my lord, upon notice I am mentioning. The petitioner is a widow, my lord. He has filed an application for seeking of grant of widow pension. For the last 6 months, my lord, the widow pension has not been, my lord, allotted. 3 applications has already been made, my lord. I think
Widow pension,
438 of your lordship's month of days list, my lord. My lord, I have,
widow pension, who will release the widow pension?
my lord, the authority is, my lord, the,
Is a family pension
my lord, no, my lord.
of
the-
freedom fighter,
not freedom fighter. There is a scheme of widow pension under the state
social
of West Bengal.
welfare.
Yes, my lord, social
Hmm.
welfare scheme, my lord.
To how much? 2000?
My lord, 2,500, my lord.
Ah.
My lord, we had the petitioner has made an application for the last 6 months. My lord, 3 applications has been.
Earlier it was she was getting the.
No. First time this application.
What is the age?
My lord, her age is 63.
63. When you applied for the.
My lord, 6 months back, my lord, the
63 is the senior citizen or 65 is the senior
no,
citizen?
60 is the senior citizen.
60 is the
Subject to correction of the lordship.
I don't know.
My lord, item number.
As per the scheme.
Yes, no, my lord. As per the scheme, it's 60.
60. I don't know. I think it is.
I shall try to satisfy your lordship. My lord, item number 438, my lord, I have put on the other side on notice, my lord. Any day convenient to your lord.
Item number 430.
438,
438
Reboti Rani Sardar.
5 तारीख को रख दो 5 फरवरी 5th February
I shall again serve a notice on my orders.
urgent.
Sir,
Yes,
upgrade-
call the list.
Great, upgrade motion.
Item number 1.
Nobody is here.
Met with the issue.
Item number you are appearing.
Yes.
Withdrawal.
Yes, my lord.
Have you got the instruction?
I have got in, but one thing, my lord, I just served the notice on the learned advocate for the Union of India. Their presence should be required. I
For
have
withdrawal.
I tell you, lordship, why? Because there has been a little complexity in this matter.
Huh?
There has been a very little complexity in this matter.
Ah.
My lord, initially, my lord, the matter is about, my lord, invocation. There was a threat of invocation of bank guarantee,
Ah.
my lord, with respect to a contract by the railways and, my lord, to my client.
Hmm.
And, my lord, challenging that, I have come before this honorable court by way of filing this writ petition.
Ah.
I was, my lord, obtained with this order of, my lord, injunction on the bank guarantee,
Hmm.
invocation of the bank guarantee.
Hmm.
My lord, after this, my lord, challenging that order, my lord, writ petition was disposed of.
Hmm.
My lord, challenging that order, my lord, the railway went up before the honorable division bench.
Hmm.
The honorable division bench, my lord, relegated this matter to your lordship's back,
Hmm.
my lord, by keeping this interim order of bank guarantee, but once again, my lord, to deal with the litigation, my lord, on merit.
Hmm.
So after this, my lord, the matter was not taken up. Now, my lord, I mentioned this matter. In this meantime, my lord,
Hmm.
there has been, my lord, a process of arbitration
Hmm.
that is right now happening between me and, my lord, the railway. So, my lord, the date is fixed today.
Hmm.
My lord, the honorable, the retired justice has been, my lord, appointed as an arbitrator by the order of this honorable court. The disputes are same over there. So this is why the pendency of this particular writ petition, my lord, is basically standing in the way in the arbitration proceeding. So I will be withdrawing this writ petition. Only, my lord, if they would have, my lord, appeared before your lordship, I would have prayed to your lordships that during this process, the interim order which is given for the for
What is the interim order?
lordship kindly sees.
Restrain the appellant from invoking the bank guarantee
Yes,
till the finally heard.
yes.
So now it is to be heard. But now the arbitration proceeding is there. In the arbitration proceeding, has any application for not to invoke the bank
My lord,
guarantee?
that is already there.
Hmm.
My lord, if I just could take your lordship, if this is why, my lord, I was just requesting your lordship, my lord, this is the order appointing the honorable arbitrator in this matter.
Okay, then you issue the notice to the other side.
I'll once again
Who
do
is
that.
appearing for the railway?
My lord, problem is this, my lord, today is the date, my lord, posted by the honorable arbitrator.
Hmm.
My lord, if I could just withdraw this writ petition today, only my prayer would have been, my lord, this is, I put them on notice also.
Oh, that's why you put the notice. I am fixing on next week.
As your lordship, please.
I am fixing because other side is not here. There is you are enjoying the interim order. I don't know what is their submission. Though the matters listed today is to be mentioned as per the prayer made by the counsel for the petitioner, but none appears on behalf of the respondent. Police the counsel for the petitioner submitted. He will issue the notice to the respondent and fixing the matters to another date. In view of the submission made by the counsel for the petitioner, let the matter appear on 29 January.
My lord, could it be, my lord, the coming Tuesday, my lord, I'll be putting them on notice. Let it be on the to be mentioned heading
Then 22nd comes.
as you
22nd January.
under the same heading, my lord. I'll be grateful, my lord. I'm so grateful.
Same as in to be mentioned. Huh? Yes, next. Not fine, no fine.
My lord,
Yes.
my lord, this item number 2, it has come up, my lord, at my instance, my lord, is for extension of interim order. I mentioned.
There is the interim order.
My lord.
Earlier,
But I am,
because there is no file here.
my lord, I am, my lord,
I
carrying
am
on
for the state, my lord. This is ready matter. It can be, my lord, disposed of any, my lord. I will not take more than 10 minutes.
Sure.
Sure.
my lord. Well, this is the last order, my lord, indicating that the interim order is expiring on my lord 16. That is, my lord, today, my lord. And I have the first order also, my lord, where, my lord, the interim order
Affidavit
was passed.
completed.
Affidavit
No,
completed.
my lord, they filed a report, my lord. We
Report in the form of affidavit.
they filed a report in the form of affidavit, my lord. We filed our exception, my lord. And my lord, this is the first order, my lord.
Okay, whatever it is, there is an interim order.
My lord.
Until further order, whichever is earlier, 16 June. 16 June, we are on 16 June. Yes.
We are on 16 January, my lord.
So, What
Let
the-
it be, my lord, for 10
Let-
day limited time, my lord.
Let it be extended, my lord, for a.
देखो फरवरी में कौन सा डेट खाली है?
And I will not take more than 10 minutes.
Okay.
My lord, I am being led by Mr. Bilwadal Bhattacharya.
Who?
I am being led by Mr. Bilwadal Bhattacharya.
The dispute relating to a godown, the Panchayat claim that it is his godown, but it is the government land. I am for the government.
26. The matter is listed as to be mentioned for extension of interim order on the prayer made by the council for the petitioner. It is submitted that the interim order is still today and paid for extension of interim order. Learned counsel appearing for the respondent state submit that interim order. The respondents already filed a report by way of an affidavit, and thus they may be treated as affidavit. The petitioner already filed exception to this said report. He prays for fixing a date for hearing.
My lord.
In view of the submission made by the council for the parties, let the matter appear on 26th February at 2026 at 2 p.m. As is especially fixed matter, interim order is extended till 26 February 2020.
Deeply obliged.
ऐसे फाइल में रख के ना इसको लगा दें. Yes, next.
Grateful, my lord.
Deeply obliged.
It appears, my lord, money has not been refunded till date, my lord. But say, for instance, a person would not have been an advocate. What would have happened for 3 days? The matter has been taken up, my lord.
Now, instruction is we have even bank. There is no reversal.
My lord,
Lord, so far as-
someone should be, my lord, directed to come and personally appear. The secretary should come and say, person who is controlling the account.
Lordship,
Who is for the bank?
And for the bank.
Yes.
As per the we have.
Which bank?
Canara Bank.
Canada Bank has given. Previously, Canada Bank has submitted that it is lying in the
SBI account.
SBI account of the state
but
bank.
SBI is not here.
SBI is not a
But
party,
about
but
the last
state
petition, Lord,
government is the account holder.
Yes, yes. My lord, I am the account.
Some secretary should come and say.
Bank.
My lord, we had asked for the instruction. My lord, there was a report to be filed today. My lord, we haven't have it today in my hand. My lord, I have verbal instruction. It will be done by this course of this day.
It has to be
My lord,
recorded.
either my lord keeps it, my lord, on the next day, my lord, or my lord lordship passes.
So I am, who is the account officer? I am telling to appear before this
Yes,
court along
my
with the
lord.
check.
Someone has to take
But
Along with the
responsibility.
demand
This
draft
cannot
in
go
the
on.
name of the petition, let he appear before this court in
My lord,
person.
may I, my lord,
That-
make one submission?
for that is the purpose. The purpose should be solved.
Yes.
May I make one submission, my lord? Instead of my lord, asking my lord directing my lord the person to appear in person, my lord lordship.
Or you are taking the responsibility, you will bring the demand draft, then I will not ask to appear in person, but you bring the demand draft.
Yes, my lord, there are two aspects of my lord, my appearing before your lordship. My lord, one is I am a creature of instruction, my lord. Without that, my lord,
So if you are not getting the proper instruction, why you are appearing before the court?
my lord, so far as my
So
lord,
you are the responsibility when you are
officer
appearing.
of the court, my lord, kindly keeps it on the next day. My lord, I'll come back with instruction. Otherwise, lordship may pass any order.
Don't
This is
try
the
to
last-
defend someone who is not giving you instructions.
This is the fourth day,
But this is
third day,
Third day.
my lord. Yes, my lord.
the third day. Then
I will, my lord, give me one last chance.
Simple
If it
thing,
is
my
not,
lord.
I will not stand in the way. My lord,
Petition has to be
appreciate the
moved.
concern
3
of
days.
my
Matter is being
friends,
taken up
client,
before the honorable judge.
senior friends, client, my lord. I appreciate the
Not senior friends, client. But it's say, for instance, this person is not an advocate.
you are appearing for whom?
state, my lord.
State government, the account holder, in whose account the money is saying as of today.
The Learned counsel appearing for the state
যদি না দিতে পারে
press for
হ্যাঁ
a day's time
করবো এটাতে
to appraise before this court whether the amount is debited in the account of credited in the account of the petitioner or not. Full stop. As a matter of last chance, the state is given liberty to file a report if it is made clear that by the next date fix, if the state failed to justify why the state has retained the said amount instead of reverting the said amount in the account of the petitioner. क्या बोला? They failed to explain why the amount has not been reverting the said amount in the account of the petitioner, comma, the concerned officer is required to be appear before this court. Let the matter appear on 22nd of January 2025 under the 2026.
Lord, I am most grateful to your lordship.
22nd.
And my lord, our submission I have already given.
That already there.
Been recorded.
Last occasion I recorded your submission.
Yes, my lord.
My lord, it is best the my lord has fallen from my lord. The demand draft will be handed over to the writ petitioner. No.
That's why, if not, I will see to them.
Sending
Yes.
the same in the account.
Next.
Grateful to you. Lord.
Because I am for the writ petitioner in this matter. This has been mentioned yesterday, my lord, because it was earlier moved before the bench having the determination of group 7. And there was also an interim order of protection till yesterday. Now the matter is very urgent in nature, my lord. The matter is this: the petitioner is a registered licensor with the railways, and in that capacity, my lord, took part in one auction initiated by the railways on 4th of December 2025 in respect of one car parking adjacent to Dakshineshwar temple, my lord. He emerged as the highest and successful bidder, and accordingly, it was signed unqualifiedly and unconditionally and generated in the account of the petitioner. And thereafter, my lord, it under the provisions of the freight marketing circular of 2022, it is the duty and the responsibility of the railways to execute an agreement within a period of 5 days from that day. Now, what had happened, my lord? They have taken my earnest money and converted it into the security deposit. They have retained it as per Section 8 of the Indian Contract Act. Now, thereafter, what has happened? Petitioner was waiting for execution of the agreement. All on a sudden, on 17th of December, my lord, the railways again floated another tender in respect of the same self-parking space. Now, my lord, after coming to know about that particular aspect, my lord, petitioner made a representation before this before the competent authority for immediate execution of the agreement. Competent authority did nothing. Now, thereafter, my lord, petitioner received an impugned letter on 30th of December 2025 stating that his bid has been cancelled. Now, the bid which was second tender, which was floated illegally, that was to be opened on 1st of January 2026. Now, on 1st of January 2026, that tender was withdrawn for some unknown reason. Now, my lord, I am before this honorable court. I have impugned the 30th of December cancellation of the bid because as per the Contract Act of Section 5, Lordship is well aware. I am just handing over the book. Lordship, kindly see, if they have accepted my bid sheet, which has been generated to me unqualifiedly and unconditionally as per Section 7, then as per Section 5, they could not have floated the fresh tender. They could not have rejected my bid. They could have done so before communication of the acceptance.
Where is our acceptance?
Acceptance is, Lordship, at page.
So you got the interim order?
Yes, I got an interim order.
Where is that?
That is on the that is there.
Which date?
Which date, my lord? I moved this. It was Lordship, kindly see it was already there by Honorable Justice Smita Das Day, and it was till for a week. That is for 15th. Yesterday, my lord, the matter was released for want of determination, and interim order was there till yesterday. Now, my lord, kindly see the bid sheet which is at page 26.
In the meantime, does not restrain from taking any steps. Yes.
Yes.
So, yeah, what is your contention?
First concern is till date, he has not served this writ petition upon the Minister of Law allows respondents. He took leave praying for urgency for one writ petition, and he served us another writ petition. Your Lordship has one writ petition, but we have two writ petition.
You have two writ petitions?
Yes.
No, my lord, may I
Yes.
And we have two writ petition. And the second writ petition, he has not.
You all persons have left all the decorum of the court.
No. That is not the correct thing I was stating. I have.
No, the court will come to you. Yes, where is the which two writ petition you are?
This was the one writ petition served to Ministry of Law and Justice. Thereafter, by this letter, he served us another writ petition. The prayers are different here. Here. Duto ache na second.
Yes. Prayers are different. issue is same.
How many writ petition you have filed?
My lord, may I clarify this, right?
Huh?
May I clarify?
How writ petition?
No
how-
writ petition was
So
filed.
this is-
No, that writ petition, first writ petition was never filed. First writ petition was.
Have you served the writ petition?
I have served.
Yes, sir.
May I clarify
Sir.
this, my lord?
Yes, for
When the
proving
second
vaccination.
tender, just a minute. When the second tender was floated,
Hmm.
my lord, I intend to move it before the vacation bench on 29th and 31st.
Hmm.
So I affirmed this affidavit,
Hmm.
but I didn't file it
Hmm.
because of the reason on 30th of December, they have cancelled my bid sheet.
Hmm.
So that changes the cause of action, and I intend not to file it, but to prefer another writ application before the regular bench.
Hmm.
And this was the letter, and upon filing the second writ petition, upon filing the only writ petition, my lord,
Hmm.
I wrote a letter, the advance copy which I have served,
Hmm.
that should not be taken into account.
Where is the
Yes,
where is the letter?
This is the
আমাদের কাছে নেই no
আমাদের
notice
কাছে নথি
no
নেই।
notice with me
yes, notice has been served, my lord. Kindly see.
no notice with
I have clearly stated.
this is the notice Hmm.
চিঠি দিচ্ছ একটা কপি দাও কি জজ
সব জানো,
কিছুই জানি
know everything.
কোর্টকে যারা দিচ্ছে সেটা একটা কপি দাও
সব দেবো।
To whom you have served?
To the department, concerned department.
See, there is a receipt of your department.
So, my lord,
Hmm.
I have not
Okay, you
filed that writ petition. That was only affirmed,
Hmm.
and that was withdrawn by this letter. And upon the change in cause of action, I have filed this second. I filed this only.
Okay,
writ
so
petition.
you are enjoying the interim order.
I was.
So what is your contention with regard to the interim order?
ছেড়ে দিন না এবারে
What is the contention? The interim order already has got the interim order on 8th of
No.
January.
alternative remedy he had there's an
No.
arbitration clause
blood the interim order is given blood for taking it even for alternative remedy blood
Ah.
yes that's why blood interim order was passed
Correct.
yes and right now blood
What is your submission now?
right now blood tender itself has been cancelled so what remains
They should-
Where is the cancellation order?
I have annexed it.
30th of December
Page
After acceptance? After acceptance, page 55.
Page 57, my lord. Page 55 is the impugned
and
splitting
blood
order.
blood he submitted representation and blood we have clarified why cancellation was given page 55 page kindly have a look page 55 blood
Yes.
everything is clear blood and whatever we have done within
after signing it
yes
Where is the
Let-
acceptance? Where is the acceptance letter?
Acceptance is at page 26. At the bottom, my lord, kindly see.
Page 26?
Yes, my lord. This was the bid sheet which was generated.
Hmm.
I-
Where is that acceptance?
Yes, my lord, kindly see. Signed on 5th of December 2025.
Hmm.
Signed by Jaisram Meena,
Jaisram Meena.
Auction Authority, Senior DCM Shialda. And in the middle portion, Lordship will find highest bidder. My partnership firm name is appearing, Ravi Enterprises. And kindly see the provisions.
Where is the Ravi Enterprise?
Highest bidder details in the middle column, my lord. Lordship has found
Yes,
that is Ravi Enterprises.
correct.
Now they have accepted it. on
What is the date?
5th of December
5th of December. Correct.
2025.
And where is the cancellation?
Cancellation on 30th of December, that is at page 55.
30th. Page 55. Is the
kindly have a look page 55
Page 55.
Lord,
that is
I am
the
reading-
cancellation after acceptance.
blood I'm reading
Just. Reference to history, relevant to So the portal, instead of the date has been wrongly as a January instead of a November instead of January.
Yes.
That was
Yes.
the
So why you not given the why you not given the corrigendum?
No, it is not allowed
No.
in the e-portal.
Mlad, Mlad, e-portal it is not allowed, Mlad. That's why, Mlad.
E-portal not allowed. You could
Yes.
have been communicated once he has been highest bidder. You could have been given a letter. If it is not accepted through the e-bidder, you could have been given a letter.
Mlad, e-portal doesn't permit.
Okay, he accepted.
Yes.
Subsequently, you
And-
find there is a defect only with regard to the date.
Yes, Mlad.
Okay, date it cannot be corrected in the e-portal. I appreciate your
Yes.
submission,
Yes.
but you could have been given a manually letter. Why you not given a manually letter? It should be treated as a
Well,
2nd January instead of 2nd November.
Even manual letter will not be allowed, Mlad. And Mlad,
Where which condition in manual letter is not allowed?
and Mlad,
Which you show me the law. The manual letter is not allowed. Show me.
Gem portal is-
and Mlad, from past 2nd January to 2nd November, Mlad.
Huh.
During this period, Mlad, that can be vacant. That's why, Mlad, we have.
That's- Cannot be vacant if you
Yes.
give the letter to him. So it could be treated as a 2nd January instead of 2nd November. So where it would be the vacant. So he will continue with that as per the tender which you accepted.
Through e-portal, Mlad, it cannot be
Sir,
allowed.
that's what I'm telling. E-portal, okay, I appreciate e-portal. The date cannot be corrected. Correct.
Yes.
But you have accepted the tender. You accepted the tender. He is the highest bidder.
Yes.
Now, subsequently, you find there is a date, there is a mistake in date, 2nd January, 2nd November.
Yes.
Correct. So you can give a manual letter because your file is there. Tender file is there in the department,
Yes.
not in all the things in the website.
Mlad, may
All
I-
the things will be in the web.
Mlad, may I submit one thing, Mlad? Mlad, kindly give me one week time. During this time, Mlad, I have to take instruction.
Take
regarding-
instruction. I am continuing the interim order.
My lord, may I take your lordship to the provisions?
Clause. I am challenging the maintainability of the writ petition.
Oh, I am keeping open.
36. That may be kept.
I am keeping open if you are challenging the mentality, but you come with the report.
Yes, Mlad. And Mlad, another thing, Mlad, page 36, Mlad.
Ah.
Arbitration clause is there.
There is no contract.
Arbitration will
clause-
come later on unless you are cancelling.
Yes.
Where is agreement entered?
For tender, this clause.
Mlad,
Okay, whatever you request.
that marks-
My lord, interim
Mlad, accepting,
be provided.
The-
Mlad, accepting the clause, Mlad, whatever we have done within the periphery of tender clause. Mlad, kindly-
Okay.
Mlad,
Come-
kindly have it.
Also now soon you'll feel with come
Mlad,
with
kindly ha-
affidavit.
Mlad, kindly have a look.
Lordship, the
Mlad, kindly have a look
Just
at
a
the
minute,
bottom. Mlad, kindly have a look at page 55 at the bottom, Mlad.
yes. Hmm.
Whatever we have done within the purview of tender clause.
That's why I have
And
going
he has
through
accepted the
this.
tender clause there.
I have gone through your paragraph 3 of your page 55. But your only contention, only the character. It is not that there is another technical difficulties. Your only contention with regard to the date. If this date will continue, he will start the work in November 2026. So till November, that will be a difficulty for the parking area. That is the
Yes.
question. So only the date you can correct it. That's why you take instruction from your concerned authority why the date cannot be corrected manually by amending the date from 2nd November 2026 to 2nd January 2026. If it is possible, then it can. If it is not possible, come with the proper, which is the law, it cannot be.
Yes.
If it is a e-tender, it cannot be manually, it cannot be changed. Come with the proposition. What is the proposition of law as per your manual? Correct? The council on the petition is the matter is listed as to be mentioned on the prayer made by the council for the petition. The petition submitted when the petitioner has moved the writ application, this court, the coordinate bench of this court has passed an order restraining the respondents for taking any steps for floating any tender. Police. Today, London Council, London Council appearing for the respondent submit that though the petitioner was the highest bidder, but subsequently after completing the bid process, it was found that in the e-auction letter, the date has been mentioned in the portal. The date is mentioned as 2nd November 2026 instead of 2nd January 2026. Accordingly, the authority was find that it is accordingly, the authority has taken a decision for cancellation of tender and floating a fresh tender by specifying the date. Full stop. This court finds that the only because of correction of the date in the portal, the authorities have cancelled the tender. Instead of instead of making any corrigendum by amending the date from 2/11/2026 to 2nd January 2026. Learned Counsel for the respondent prays for time to take instruction and to file report by way of an affidavit. Let the report be filed by
30th, Your Lordship.
30th January.
30th January 2026. After serving the copy to the learned counsel for the petitioner, the petitioner is liberty to
My lord, we have
file affidavit, file exception to the report, if any, within 4th of February 2026, link the matter on 5th of February 2026
my lord, we have
under the same heading, full stop. In the meantime, the respondents are restrained from taking any steps to floating any.
my lord, maintain limit point kept
The
open.
respondent authorities have
Pertain
raised
to
the point of
arbitration
matter,
clause
the
at
same is
page
kept open.
36.
The same is kept open.
Yes, ma'am.
Great.
13th February.
Lordship is desired to take this on 5th of February. Great.
5th January, 5th February,
Interim order is still that day.
till then.
Great.
30 you have to file, give the copy, they will file the reply, matter will be listed on 5th.
Great. Great.
Take your book. Next.
I'm for the petitioner.
Yes, call.
For
Item 6.
for the convenience of your losses, I prepared a list of things so that I need not take your losses.
Lord, I am appearing behalf of the private respondent number 11.
Private respondent
11.
11.
Lordship, I am appearing for the board.
Board.
May I take your losses to this list of debts?
What is the matter?
Matter in regard to admission
In the
in a school.
whether this court is having determination.
No, your losses right now determination.
Right.
But this was substantially hard when I mentioned before losses justice by Justice Om Naran Roy. But on the day this was heard, and thereafter another day substantially. But determination in regard to irrespective of classification changed, and this was made up to 22. This was 2024, but that was 2024 before that. So this has.
Okay. Yes.
I will not take. I will be precisely for your losses.
Yes.
No, I just take your loss in list of days, then I will make the point of law. Your losses kindly see 1965, 6th January, Goura Sonamui Co-Education School was recognized by board as a co-education school. Well, on the right hand side, your losses gets the page and paragraph. On 2nd December 1980, your losses almost after 2 decades, Sonamui Girls School recognized by the board with effect from session 1989, which is situated within ½ kilometer from the Sonamui Co-Education School.
So Tsunami Girls School is established separately
Separate.
after 20 years. 23 years.
3 years.
Okay, I will come. Please take your seat. Yes.
Now, 11th December 1988, the managing committee of the Sonamui Girls School adopted a resolution to request the board to withdraw the co-education status of Goura Sonamui Co-Education School, citing board circulars dated of 1995 and 1956. What the circular says, I will take your loss. 12th September 1991, order of the board to discontinue co-education permissions from Goura Sonamui Co-Education School. 6th March 2008, writ petition moved by Sonamui Girls School for implementation of the board's order dated 12th September 1991. By an order dated 6th March 2008, this honorable court directed the board to consider the representation of the girls. On 2nd September 2004, by a letter dated, board requested Sonamui Co-Education School to take steps to discontinue co-education from classes 5 to 8. 5th October 2004,
letter dated 2nd September 2004 of the Secretary of the Board questioned by some guardians by way of a writ petition being such and such number. By an order dated 5th October 2004, this court stayed the operation for 2 weeks after ensuing Puja vacation. 2nd December 2004, interim order passed. In writ petition was extended until further orders. 28 June 2013, writ petition was dismissed for default. Malad, I request your lordship pause here for a moment. When the writ petition was moved in 2004, when the writ petition was dismissed for default 2013, almost another decade over. Therefore, those words passed out. They lost their interest in the writ petition, nobody will turn up. So automatically got dismissed for default without deciding the matter. 11th April 2012, Nimai Chanda Mehta of Sonamui Girls Schools, before that, moved a writ petition, being a writ petition number for implementation of the order of the letter dated 2nd September 2004. While order dated, such writ petition was dismissed with cost. This was moved by Mr. Borua's client, Sonamui Girls School. Necessary, I will take the observations of the court also for that. 15 July 2014, administrator of the board, while order dated repetition, passed an order in terms of the order dated 6th March 2008, passed in the first writ petition moved by the girls' school, holding that in case of breach of the board's order dated 2nd September 2004, the board will take stern view in the matter. 6 January 2014, a writ petition was moved by some guardians of the girl students, questioning the order of the administrator dated 15 July 2004. While order dated 6 January 2014, this court, Honorable Court, was pleased to direct the girl students who have already been admitted in the co-education school to continue their studies. I'm going to pause here for a moment. Because of this continuation against at girls school students admitted, so they wanted to save their admissions because of the repeated orders of the court. And 23rd February 2017, a writ petition was filed by some guardians being such and such for permission of co-education. Order dated 23rd February 2007, this Honorable Court was pleased to direct the board to consider the representation of the guardians dated 4th November 2016. 11th April 2017, board passed the order passed by the president of the board as impugned in this writ petition. Lord, kindly take note of your losses. This 11th April 2017 and order dated as far back as passed on 2nd September 2004 has been questioned by the present petitioners who are the guardians of their wards who wants admission of their girl students in the school under the respondent number 6 and respondent number 11, the girls school opposing that prayer before your lawsuit also. Now I take your losses. I am moving the questioning both the orders on the ground. First, the order of 1995 has been misconstrued and misread by the board itself. That has no applicability in the present facts of the case. And second submission of mine, the even melody laws of 1995 that archaic order after the Constitution and the Right to Children Education Act, Article 21A. Denial of admission on the ground of sex is unconstitutional. These are 2 points I'll be urging. Only one thing I tell your lordships, as a parent of the girl wards, I have a right, fundamental right, to choose the school. And paragraph 7, your lordships kindly take note of. I have said why the school is better than the other school in the area. I have a choice on merit, not that any concession. On merit, I have the choice. Now, your lordships kindly have a look at the impugned order at page 12, 131. I just take your losses to that. Now, this I have to place it, your loss.
Yes.
The problem is admission of girl students in Goura Sonamukhi KB Sanksikkhayatam. Though there is a girls' school, namely Sonamukhi Balika Vidyalaya, the people of the locality have a tendency to admit their girls in Goura Sonamukhi KB Adorsha Shikhayatam. That's co-education. The girls' school is confronted with an existence of crisis because of sharp decline in the roll strength, where co-education boys' school situated within 100 meters of the girls' school has registered abnormal growth in respect of the admission of the girls' students. As per the direction of the Honorable High Court, a hearing was taken by the administrator of the board. The board directed the boys' school not to continue co-education in violation of the earlier direction dated 2nd September 2004. If the boys' school still ventures to continue co-education, this office will be left with no option other than to take stern view in the matter. Being agreed by the decision of the board, some guardians have filed instant writ petitions. They are interested in admission their girls in such institution which has a good reputation, but to directive of the board, they are unable to admit their girls from classes 5 to 8 in Gora Sonamukhi. The Honorable Mr. Justice Sachin directed the concerned authorities to dispose of the writ petition. Well, then your lordships kindly see the following persons who are directed for hearing. Then I am go to the findings. Although the scrutiny of relevant documents and taking into account the submissions made at the time of hearing, it revealed that the total roll strength of the girls' school is around 200. The school has been converted into a sponsored institution on 2015. But what is strange is that Goura Sonamukhi KB Adorsha Shikhayaton has admitted 33 girl students in the year 2025, violating the order dated 6 January 2025, passed by the Honorable Court in WP number such and such. Also directive issued by the board, conveyed by memo number 2014. The HM of the school has himself admitted these facts at the time of hearing. There is at present 52 girl students in class 9 and 53 girl students, 10 and 52 girl students in class 12. In the president of the board disposed of the petition, upholding the earlier decision confined by the authority of the Goura Sonamukhi is once again to not to admit any girl students in the secondary level for any day. Now your lordships will find the order. Now, therefore, your lordships will find here two things. First, admittedly, the co-education school, which described as boys' school, established long before. Now, subsequently, after 23 years, girls' school was recognized. Now, my lord, kindly take into consideration the impugned or my lord, board's circular. That's at page, I take your lordships, page 61. Page 62, your lordships need not go into the details, only the relevant clause, page 62. There is another order, I will take your law.
Yes.
Permission for girl students in any class shall not be given where there are girls schools in the neighborhood within a radius of 1 mile in a city or town and within 2 miles of a school situated in rural areas. Also, if such girls schools in the neighborhood are in a position to admit the additional number. Apart from constitutionality or unconstitutionality of it, according to my submissions and understanding, this applies when the girls' schools recognized and established prior to time, not established prior thereafter. I just kindly read out again once again. Permission for admission of girl students in any class shall not be given where there are girls' schools in the neighborhood within a radius of 1 mile in a city or town. So therefore, it presupposes existence of a girls' school in point of time earlier.
Correct.
Subsequently, this cannot be done. This is one thing.
Even where the girls' schools in the neighborhood within. So your question is that your submission is that there was earlier when it was established, there was no girls' school.
So therefore, this cannot be applied
this
because of
subsequent application. They cannot change the law.
This is one thing. And another thing, my lord, this is very ridiculous. The one order I placed before page 131. Just once, your lordships, kindly come, your lordships. I will now your lordships will find.
Now, what
though
is
there
the
is a girls'
what is
school-
the date of this
131 page?
162?
162.
No, this 62 which you referred to.
And that's your losses. And 61, your losses kindly.
What is it?
16 July 1956.
1956.
6. Well, we are still in that era because of empowerment of without empowerment of
Okay.
women. Now, kindly have a look at page 131.
Yes.
Just first line for your lordships consideration.
Yes.
The problem is admission of girl students in Goura Sonamui. Though there is a girls' school, namely such and such, the people of the locality have a tendency to admit their girls in Goura Sonamukhi school. The girls' school is confronted with an existence crisis because of sharp decline. Malad, this is a malad situation we are now malad existing. Is a matter of competition on merit, both in respect of students as well as the schools. If a parent finds that X school is better in respect of all, he can malad aspire his or her girl students to be admitted on merit. Can it be a ground, my lord? According to me, this is ridiculous that he loses his admission. Sharp decline. If this is so, your losses, government stand would have been, my lord, or board stand, withdraw their recognition and amalgamate it with any other schools. But you cannot deny the admission on the basis of sex. Just because I'm girl student, I will not. That's why I will take your lordship paragraph 7. This is the co-education rules, fully computerized school.
Yes.
Huge malad infrastructure. So I get my students to be admitted over that.
Yes.
Now your lordships, before going into the point of constitutionality, I take your lordships page only 63. This is the order, your lordships, staring at the face of all the guardians coming from time to time, all the time to come. Of 2nd September 2004, you were requested to take steps to discontinue co-education from class 5 to 8 in our school right from this academic session, as the permission of the same has long been withdrawn by the board.
Yes.
But before that, malad, we are not aware of any fact, all that. Now I tell you, lordship, subsequently, they withdraw the permission up to 10.
Yes.
Now the co-education, your lordship, still survives in 11 and 12, if I'm not wrong. So these are the factual aspects your lordships will find. Now your lordships kindly consider only one thing. Paragraph 6. No, paragraph 7. Well, just a look, malad, why I'm saying the guardians are saying that this is a school with better equipment, better facilities. I want that school. No one can restrict me to go to that school when this was initially established at co-educational school. Now, your lordships, this sort of circular of 1956, malad, prevailed in other state also.
Yes.
Earlier. I just take your lordships to one judgment. I believe your lordships record that judgment is there.
Which judgment?
Just
Allahabad High Court?
exactly.
This is Khadju?
Just kindly allow me to place it entirely. It is written in such a. There is a boys institution called Allahabad Intermediate College, which is recognized institution under UP Intermediate Education Act. The institution was started in 1910 and has throughout been a boys institution. The allegation in the writ petition is that from the session 1992-1993, the committee of the management is going to admit girl students, and it is alleged that this is a violative of regulation 8.81 of chapter 7 of the UP intermediate regulations, which states girls shall not be admitted into boys institutions without obtaining prior approval of the inspector. Now kindly see, malad, we are asking for admission. They are showing me the rule, and here your lordships, some of them come up to stay the state school's hand, not admit any girls. By means of this petition, the petitioners who claim to be students of this institution have prayed for a direction to the committee of the management of the institution that it be restrained from admitting girl students. I have heard the learned counsel for the petitioner, learned counsel for the respondent, for the petitioner has urged that prior approval of this has not been taken before admitting girl students on 15th October 1992. I had passed an order granting 2 weeks time to the standing council to file such and such. In my opinion, Regulation 8, Chapter 7 of the regulation is arbitrary and hence violative of Article 14 of the Constitution. Pause here for a moment. Somebody wanted to implement this. Court says this was not challenged. Rather, they wanted to implement. The court says this is unconstitutional. I cannot do that. In my opinion, educational institutions segregated on the basis of sex are a sign of backwardness. The sooner this segregation is done away with, the better for the country. It is my firm belief that all educational institutions at all levels should be co-educational. Co-education is healthy and good for the development of the personalities of both boys and girls. If there is a co-education, boys and girls will know how to interact with each other in a healthy manner. And this will also help them towards social adjustability. In sexually segregated schools or college, boys and girls live in inhibited environments with false notions and fantasies about the opposite sex. Co-education will make children more mature and more realistic. A lot of eve-teasing and other such harassment will stop if there is co-education. Even rowdy boys are likely to improve in a co-educational institution since they may not wish to incur the social disapproval of the young ladies of their class. Similarly, girls will get to know the nature of young men better and will learn to interact with them in a healthy manner. At present, the situation in most places is that the young men and women who have studied in segregated institutions till the age of majority are awkward and often dumbfounded and tongue-tied in each other's presence. A young man does not know how to interact with a young lady and behave in her presence. And the young lady is terror-stricken in presence of a young man as he has only interacted with her father and brother till then. This segregation leads to several kinds of psychological and social problems, and hence it should be done away with. In fact, all modern countries have co-education. Article 39A of the Constitution states that the state shall in particular direct its policy towards securing that children and are given opportunities and facilities to develop in a healthy manner. In my opinion, development in a healthy manner for children is best possible in co-education. The right to co-education in Articles 41 and 45 must be construed consistently with Article 39F. In a paper entitled The Psychological Perspective of Adolescence, a rationale for co-education, Mrs. Camila Thapar, lecturer in physiology, department in the Allahabad University, has said, it would be tenable to argue that co-educational system as opposed to same-sex schools would provide an opportunity to adolescents to interact with the same gender as well as opposite gender peer groups. These should prepare the ground for a healthier, more open interaction between the sexes and would promote the healthy attitudes towards the issues of sexuality. Also, co-education offers a first-hand opportunity to observe the behavior patterns of other adolescents of the same and opposite gender, and the advantage to accruing would be twofold. The adolescents would be able to sharpen and refine his or her personality and identity. Sex role identities would be more clearly articulated and defined therein, also ensuring problems would be more easily resolved. Thus, the adolescents' perceptions of issues of identity, friendship, sexuality, all critical significant issues at this juncture as well as for future well-being would be influenced by experiences in co-educational system. It is hoped as this system enables a freer interaction between two sexes, the adolescent would not always minder through a terrain hewn out of fantasies of intimacy, a landscape whose contours are shaped by more obscure desires and fears men and women entertain in relation to each other. In view of the above, I am clearly of the opinion that the regulation 8 of chapter 7 of the intermediate edu is arbitrary and violative of article 14 of the constitution. Hence, it is not necessary for the committee of the management to take prior approval of the district inspector of the schools before admitting girl students in a boys' school. The writ petition therefore fails and is dismissed. No order as to cost. Board, before parting with this case, I would like to make a recommendation that all schools and colleges in the state should gradually become co-educational. This can easily be done by making class 1 co-educational in the first year, class 2 co-educational in the second year, and so on. In this, why in a decade or so the whole school can become co-educational. I am informed in many states like Assam, Madhya Pradesh, etc., all schools except some elite schools are already co-educational. Well, it is also happens in Bengal. Not all schools, all our childs are in co-educational.
Yes.
There is no reason why UP should lag behind. Co-education will contribute towards modernization, which is the main goal of the nation. It will also help young men and women understand each other better, which will be of great use when they have to work as a team in later life. I would like to express my gratitude, all that. Now, my lord, this judgment was passed by the Honorable Mr. Kajju in as far back as 1992. Now I take your lordship. One order I have missed, I will take your lordship before I place that. My lord, kindly see, this is the report of 1974. This was not, I did not find before your lordships.
Yes, it is there.
There, I give you. I just take your losses only to the relevant portion.
6.72.
6.65. The imbalances just pointed out to make it difficult to forward a set patterns of recommendations. Beside the general problems of education, there are certain specific issues on which it is not feasible to insist upon a uniform pattern for the whole country. One such example is co-education. This issue has been examined by the various committees and commissions. In the next paragraph 6.66. In 1953, the Secondary Education Commission observed that there could be no hard and fast policy with regard to co-education, as social attitudes differed very greatly in this respect. The Commission therefore recommended opening of separate schools wherever possible. They are likely to offer better opportunities for physical, social, or mental development of the girls. Girls who had no objection should be free to use co-educational facilities in boys' schools. The Commission, however, prescribed specific conditions in the way mixed staff and teaching subjects which appeal to girls as such: home craft, music, drawing, etc., and separate facilities of co-curricular activities of such institutions. In 1959, the National Committee on Women's Education recommended that co-education should be adopted as a general policy. The board still lagging behind our board, they do not deal with that 1956 circular at a primary stage. But as a transitional measure, separate schools may be provided in places where there is a strong public demand for them and enrollment of girls is large to enough to justify separate schools. At the middle of the secondary stage, more educational schools should be started and subject to the conditions of academic adequate attention being paid to the social needs and requirements. Separate secondary schools for girls should, however, be provided, especially in the rural areas. The committee, while recommending alternative in area where co-education is not acceptable, suggested efforts to be remove difficulties and apprehension against them. But why I am citing to your lordships this chronology? Even 1959, the committee entrusted by the central government thought it co-education should be the better mode of education. In 1959 idea should not prevail over us now. This is we cannot go backward.
Yes.
Now your lordships will find what they have done, your lordships. They have girls' school said that their admission registration decreasing. And that's why co-education status of the earlier school will be recalled. This is the thing, your lordships. Now, before my lord citing one judgment, I missed it, your lordships. Kindly come to page 82. This is another order. This order also questioned, your lordships, because this is by Anna in respect of.
Yes.
the Sonamui such and such as a 4 class with effect from 86, 87 respectively. The managing committee of the school unanimously adopted in meaning that certain requesting the board to withdraw the co-education permission. I'm only on that, your lordships. The girls' school asking to withdraw the co-education permission of the co-education school. Well, what right they have got, my lord? Under what provision of law, even at that stage?
Yes.
Then your lordships will find, I take your lordships to the findings. If your lordships kindly come to my lord, page 86, findings. They have narrated whatever I have placed before in the list of dates, the different cases, all that. The girls' school is confronted with an existence crisis because of sharp declines in enrolled strength, where co-education boys' school is situated within 100 meters from the girls' school, has admitted registered abnormal growth at the cost of the enrolled strength of the girls' students. My submission, if this is, board when recognize the school, board must have studies the locality. So if when the girls are equally with the boys in a co-education school, what was the necessity?
Girls is confronted with the
Educational existence crisis. Because every girl wants to go to that school. If he doesn't get a chance, he goes to the girls' school. Her first option is the boy co-education school. Then your losses will find the very existence of Sonamukhi Khirodamoi Balika Vidyalaya is at stake in the representation dated 93 and 2013 respectively. The girls' schools prayed for withdrawal of permission for running of co-education of Goura, Sonamoi, Khejude, Adarsha Shikkhaton. It appears from the materials on record that the board withdrew such permission for running record in 2004. I have placed that order, your lordship, before lordship. The boys' school challenge, I tell you, lordship, this is wrong recording of fact. Boys' school didn't challenge. Guardians challenged, the affected guardians. The said order of the board by filing a writ petition before the honorable court and obtained the order of interim stay, which was existing from time to time. But eventually the said writ petition was dismissed for default on 8 June 2013. There is a typed copy in the next page. Your lordship may go through that.
Yes.
Then your lordship, page 88. There was automatic revival of the board circular of 2004. Therefore, representation pursuant to Justice Rajiv Sharma's order were rejected. They didn't go into the point even whether this can be permitted or not. Then one thing, I just take your lordships, that thing your lordships have the report towards equality. Just take your lordships, one paragraph. Last page, 6.72.
Yes.
In our opinion, the considerations of efficiency, economy, as well as equal opportunity require the acceptance of co-education as a long-term policy. In view of the divergent social attitudes, however, we recommend that co-education should be adopted as a general policy at the primary level. We are from 5 to 10. At the middle and secondary stage, separate school may be provided in areas where there is a great demand for them. Pause here for a moment. What is the finding of the board? There are existing crises because of the co-education school.
Correct.
Then how does it satisfy?
Yes.
Then you lost it. But the effort to pursue co-education as a general policy at this stage should continue side by side.
Yes.
Therefore, there are others your losses will find. And fourth, my lord, there should be no ban on admission of girl students to boys' institutions. This is a recommendation of the central government. There should be no ban. Now, this is amounts to ban. Now, I need not take your losses to Article 21A, unnecessary your losses, and your losses Article 14. These are the things only. And then your losses, another thing, the board also did not felt it. Somebody moved the board, and board then, my lord, wake up that this should be done in favor. My lord, I only relying upon your lordships, paragraph 20, 21, and 24. That's to show, my lord, article 21.
Paragraph 21, paragraph 21.
21, 20, 21, 24. Now, that kindly consider. The right to education is a fundamental right under Article 21A inserted by the 86th Amendment of the Constitution. Well, as soon as it is brought on record in the Constitution, the 1956 circular can be pressed into service, my lord, by an authority.
Yes.
It automatically goes.
Yes.
Then, your lordship, there has been a campaign that right to education under Article 21A of our Constitution be read in conformity with Articles 14 and 15 of the Constitution. There must be no discrimination in equality of education. Thus, a common syllabus, common curriculum is required. The right of a child should not be restricted only to free and compulsory education. Well, I draw your lordship's kind of language. The right of a child should not be restricted only to free and compulsory education. That means this should be inclusive education.
Correct.
Just because a girls' school there, a guardian is forced to take her child to that girls' school. Even the qualitatively, the girls' school is better than the boys' students.
Yes.
The right there should be should be extended to have quality education without any discrimination on the grounds of its economic, social, and cultural background. Arguments of the propagators of this movement draw support from the judgment of US Supreme Court overruling its earlier judgment, where it has been held that the separate education facilities are inherently unequal. I have given you a lawsuit, that's why in the petition, what are the better facilities over there? I'm not asking my lord on concession. I'm asking on merit.
Yes.
Then your lawsuit, paragraph 24. My lord, kindly see my lord, our High Court's judgment, again your lawsuits, in this our my lord, Supreme Court's judgment. In state of Odisha versus Mamata Mahanti, these court emphasized the importance of education, observing that education connotes the whole course of scholastic instructions which a person has received. Education connotes the process of training and developing the knowledge, skill, mind, and character of students by formal schooling. These court further relied upon earlier judgment in Osmania University, as quoted. Democracy depends for its very life on a high standard of general and vocational and professional education. Dissemination of learning with search for a new knowledge with discipline all around must be maintained at any costs. Well, kindly similar, therefore, all that I am trying to say, your lordships, this decision of the board is violative of Article 14 and 21 of the Constitution. Well, only one thing, on the last occasion, not before your lordships, they submitted, I deal with that. There are two submissions of the board that they have to see the strength of the school. My lord, suppose your lordships, strength of the school or teacher pupil ratio. My lord, I have given your lordships my lord, in our my lord, report, my lord, in the lead petition, but the board has filed a report. Your lordships can take up that report. Board file করেছে তো?
Report or affidavit?
States, my lord.
State has filed the report.
Yes.
My lord, I appear for the statement. I filed a report in the form of an affidavit on the last occasion, my lord, in paragraph 11, my lord will find the pupil teacher.
My lord, I deal with that, my lord. Then my learned friend will deal. Now kindly see at present in the academic session of 2025. Total
Respondent number, state respondent number.
State
I didn't find any.
State respondent number 3, my lord, district inspector. Yeah,
Has you also got it now?
Number what?
It's 86.
You are having extra copy?
My lord, I have a copy in my report.
You. You are having.
I can be also. Let your copy be there. Now, my lord, kindly see paragraph 11, page 4. Now, my lord, at present, in the academic session 2025, total enrollment of Goura Sonamoi Kunjobihari Adarsh Shiksha Niketan, that means my lord co-education or boys school, what they say, is 663. And 20 number of teaching are working there, including 1 contractual teacher and 2 para teacher, and the pupil teacher ratio 32.1. Well, this is well within the law. What is to 1? First, I tell your lordships, this argument of any pupil teacher ratio is absolutely misplaced. Why I'm saying your lordships? Suppose your lordships 30 students is there, all are boys. Now I wanting my girl's child admitted in 32 itself on the basis of merit. If the merit on competition, some boys goes out, they will have to go out. That's my, this is not a question of ratio of pupil teacher.
No, the admission is only on the basis of the merit.
That's your lordship. So, what I'm on,
It's not
pupil
that
teacher
all the-
ratio is irrelevant one.
If you have having the quality and the strength has already been fixed by the school, so they cannot go beyond that.
That's my
If
point.
they not go beyond that, then the admission is on the basis of the merit only.
Board on the last occasion before the Honorable Justice Roy wanted to submit, if the ratio do not permit, how?
Correct.
Ratio do always permit on the basis of merit. I'm not wanting that without merit admit me. On merit.
On the merit, on basis of
So
merit.
therefore, this question doesn't arise. Now the state have annexed one circular. This is of 1960. But if I'm not wrong, our school was recognized as co-education in 1965. Kindly see what they are saying, that these are the requirements to be fulfilled. An application for introduction of co-education will not be entertained if it is received in this office after the date specified above. The girls already admitted may not get the concession for free tuition. Up to 8 now, everything free in aided school. The application should apply the following particulars: whether separate sitting arrangements have been made for the girls, whether separate common room facilities for girls, whether there are separate sanitary convenience for the girls, whether arrangements have been made for safe escort of girls to and from the school, whether any lady teacher has been appointed in the school. A lady teacher may not be made unless the number of girls pupils in boys school exceed 3. Distance of the from the boys school concerned. Again, distance. Distance is absolutely unconstitutional. But this is of 1960. I deal with all the points one by one. Your losses kindly come to paragraph 7 of my writ petition. So I presume that when the recognition was granted to the co-education school in 1965, this circular was considered. This was before that.
No, the problem, no, they have not challenged your recognition.
Exactly.
They only want it has to be, instead of co, it has to be given as a only for the boys.
That's, no, co-education is withdrawn.
Huh?
Co-education
That's
permission.
why they've withdrawn. They have not challenged that.
No, all that I'm trying, this was not withdrawn on the ground of the for the girls.
Correct. That's I'm telling. That's I'm telling.
Kindly come to my lord, paragraph 7. I have said what are there, what are not, because I'm the parents of the girls. Out of the aforesaid co-education institute, Sonamukhi education is the best for the reasons, namely, 3-storied building having 36 classrooms with separate sitting arrangement for boys and girls. Pause for a moment. Now, I have a reservation. Can your lordships put this condition that after a girl student, one boy student cannot sit at this 2025? This takes us to the at least 3-4 decades before. With 10 ladies toilets, 4 boys toilets, apart from separate urinals for both girls and boys teachers toilet.
Who are you? Who are you?
I'm all the guardians.
Guardians of
the girls students. Paragraph 2, your lordships. So this satisfies all the conditions your lordships will find.
Okay. That's all.
No, that's my submission.
Yes.
I will just come back within 5 minutes.
I am on behalf of the girls students, girls school. What has happened, my lord? This is the circular, my lord, that is 1950, the page, my lord, 61 of the writ petition, my lord. And the relevant provision is, my lord, the page 52. That is, the permissions for the admissions of the girls students in any class
Shall not be given where the girls school is.
This circle is still existing.
Correct.
That is, my lord, what has happened?
No,
They have-
the only thing is that
they have not challenged this circle.
no. cannot. This is of 1956,
Yes,
when the school was established.
that is school was their school.
Hmm.
Their school was
55,
65,
55,
65, 65.
65.
Yes.
Correct.
After that,
After this,
after this.
it has given the recognition.
Yes,
Given the recognition, you have not challenged that.
yes.
Correct. You're
Yeah,
not.
but one thing is this: when it is came to the knowledge of this board,
Hmm.
that two school is within a half.
No, that's why that's why I am coming on that. I am coming on that. This rule is of 1956, and the school established 65.
Yes.
When the separate girls school within 100 meter was established.
After the school 1976.
Which year?
1976.
1976.
Yes.
If the girls school established after the 1965 establishment of the co-education prior, can this given
It is demand of the villagers. There should be one girls' school. For
Correct.
that reason, board
where then you have to file a report with the establishment of the school of your girls school in 1970. Just a minute. Then you have to if you are telling there is a demand of the public for establishment of a separate girls school, then the establishment of the girls school, you have to go to the zero. What is the necessity for? So might be there is a demand of the local people. So that
the board heard the entire matter. At the same time, your lordship.
board heard subsequently.
Justice Dipankar Datta passed an order. My lord, your lordship, kindly see the order passed by Justice Dipankar Datta once. Page, my lord. Page 98.
Page
98.
98.
January 2015.
Correct.
Your lordship, kindly see. I am not reading it. It's not necessary, but what has happened? It appears, page 99. It appears that perusals of the order of the administrator that there was an earlier order 2nd September 2004 passed by the West Bengal Board of Secondary Education discontinuing the co-education from class 5 to 8 in the said Shikkha, which was communicated by the Assistant Secretary G West Bengal Board of Secondary Education memo number dated 2nd September 2004. Such memo was challenged before this court in writ petition number such and such, and interim order interim stay was obtained. Such writ application petitions will ultimately dismissed for default on 28 June 2013, and the said order not having been recalled, the memo number such and such dated revised, as a result of which the authorities of the said Shikkha were under the legal disability to admit the girls students in class 5 to 8. It further appeared that the West Bengal Board of Secondary has taken a decision to discontinue to co-education facilities in the said Shikkha, accepting that representation made by the authorities of the Sonamoi Kirodumi Balika Vidyalaya, hereinafter the girls' school. It was the claim of the authorities of the said girls' school that there was an abnormal increase of the girls students in the said Shikkha, whereas for want of the adequate number of the girls students, the girls school which was situated near the said Shikkha was immediately suffered and of the verge of the closure. I need not examine the controversy as to whether the West Bengal Board of Secondary Education justified to discontinuing the co-education facilities in said Shikkha. Since the decisions to this effect that has been taken more than a decade ago. However, having regard to the fact that such order was challenged before this court and such challenge in the effect was failed by the reason of dismissed on such and such, dismissed for default, I am of the further view that the interest of the justice would be best served if the equities are balanced, and this writ petitions is disposed of at this stage by issuing the necessary directions. Accordingly, I direct the girls students who have already been admitted in the said Shikkha shall continue to pursue their studies till such time their parents and guardians wish them to do so, or till they take the relevant Madhyamik Parikha. or other examinations, and the decisions of the West Bengal Board of Secondary Education conveyed by memo dated 2nd September 2004 and memo number such and such, enclosing copy of the impugned of the order of the administrative board, shall not have any effect insofar as they are concerned. However, the authorities of the state Shikshadan shall not admit any new girls students in any class henceforth. It is made abundantly clear that the notwithstanding the arrangements to be worked out by this order, the West Bengal Board of Secondary Education shall be at liberty in the interest of the education students of the locality to take any further decision that might be necessary, including review of the decision as communicated by the memo number such and such. The deed application is disclosed. Thereafter, in pursuance of the order of the court.
No, it is made evidently clear that notwithstanding arrangement to be worked out by this order,
Yes.
shall be at liberty to take in the interest of education and of locality, take further decision.
By the order of the court, my lord, they
Correct.
are admitting these girl students. Then, my lord, I filed a contempt application. Your lordship can turn page 110. This is the contempt application. Here, my lord. Here, my lord, your lordship, relevant question, your lordship, can you see the page 111? And I have paragraph 5, bottom. Page 111, paragraph 5. Your lordship got it?
Yes.
I have heard Mr. Mukherjee and Mr. Gorwa learned advocate for the petitioners CPN number such and such, as well as Mr. Chatterjee, learned senior advocate representing the petitioner petition number. None has disputed that by an order dated 9/2004, the board has restrained the authorities of the said Shikshadan from admitting girls students in classes 5 to 8. There was no restricting. There is no restriction insofar as the admissions of girls students in class 9 and 10. So, there is no restriction regarding the admission of class 9 and 10, 9 to 12. Therefore, the order dated 6/1/2015 cannot be read in the manner restricting the right of the applications in CAN number 1559 of 2015 to admit the students in class 9 to 12. The portions of the order dated 6/1/2015 extract in paragraph 2 shall be constituted accordingly, that is the authorities of the state Shikshadan are entitled to admit class 9 to 12. There is no, it is a co-education school. For the 9 to 12, still it is co-education school. Such time a contra order is passed by the board in this regard. Insofar as the admissible of 33 students in class 5, 6 and 9 and concerned allegedly in violations of the order dated 6/1/2015, I am satisfied that due to communication gap, the application CAN number such and such proceeded to make such admissions. There was no ill motive of the applicant to lower the dignity, majesty, and the prestige of the court, the school court. In this view of the matter, I direct the admissions grant to such 33 students would be regularized, and the board shall treat them to be duly admitted students of the Shikshadan. However, it is made clear that with the effect from the next academic sessions, the authorities of the said Shikshadan shall not admit any new girl students class 5 to 8. So, it is in only restrained the 5 to 8. And above that, 9 to 12, there is a co-education school. So, it is not correct. It is not purely it is purely other girls school. It is a co-education school. Only 3 classes. It is a 5 to 8.
So you are concerned with the 5 to 8 only?
No. Now it is that is class 12. But the order, when the order passed, that is only 5 to 8.
No, that is correct. See, now the court has passed an order, you filed a contempt application.
And
So there was a communication gap. The court has held that.
There is specific direction. There is school. There is a 5 to 8 should be.
Correct. So what has happened to this?
Thereafter, my lord, they have not admitted any student.
So what has happened to this writ petition?
Thereafter, your lordship, can you see? Justice Sharma passed an order, my lord. Your lordship, can you turn, my lord, the page?
No, Justice Datta order. That is a dispute.
Yes.
Now kindly come to the page 99.
Page 99.
Page 99, 100. That writ petition was disposed of. That is with the direction not to admit any girls.
Yes, yes. Thereafter contempt, I filed a contempt.
So there is an order not to admit.
Yes.
Correct. So then contempt is okay. Then what has happened? Subsequently,
Again, they filed.
this order was not challenged.
Yes, no.
This order was not challenged.
No order has been challenged before the division bench.
And this order with regard to the class 5th to 8th.
Yes, only class 5th.
Only class to 5th to 8th.
Class 5th to 8th. Then, my lord, again they filed an application before this court, my lord, where your lordship kindly see, Justice
sorry,
Sharma. That is the page, my lord. Page 127. 127.
Yes.
The grievances of the petitioner. Second paragraph.
Yes.
Grievances of the petitioner is that board by memo number dated such and such, as also memo number such and such, had enforced the restrictions on the guardians of the girls students who want to pursue their education in the co-education school, namely Goura, Shonamoi, Kunjobihari, Adarsh Shikkara, from class 5 to 8, whereby it has been provided that the girls students are to be admitted only an institution which has been recognized subsequently by the West Bengal Board of Secondary Education for providing education of girls, namely the Shonamoi Nivadobai Balika Vidyalaya in the same locality. But the petitioners who are guardians of the girls students are interested in admitting their work in such an institution, which has a good reputation, but on account of the said memo number such a 9/2004 and subsequently on 15/7/2014, so issued by the West Bengal Board of Secondary Education, the said institution has refused to admit their students, specifically girls students from class 5 to 8. Being aggrieved by these actions on the part of the authority, the petitioners have made a representation dated 4th November 2016 before the concerned authority, but till date, the said representation dated representation has not been decided as yet. Accordingly, the petitioners have filed the writ instant petition. Learned counsel for the petitioners submit that the section 3 of the right to children to free and
so this order which we are referring to page 127,
yes,
that is of 23rd of February 2017, and Justice Datto has passed an order on 6th of January 2015. So at that time this order was not brought to the notice of this court.
Yes, yes.
Where is that?
Yes.
If that order would have been brought to the notice of this.
This petition filed by them. Filed by the
correct. You are appearing for the authority.
Yes.
The Justice Datta 2015 order was not brought to the notice of this court.
For that, yes, for that reason, Lord, your lordship passed the order, board of direct your lordship and see the order, specific order, accordingly without going your lordship.
Correct. That's why, see, the 6th of January 2015, the writ petition was disposed of by His Lordship Justice Datto.
Yes.
Correct. Mandatory direction was passed not to admit the girls student from the further academic year from class 5 to 8.
In fact, my lord, against the filed petitions.
No, I am putting one question. Let verify that. So this is the 2015 order. Subsequently, again 2017, they have challenged the this 2004 communication, which was also the subject matter in 2015.
Yes.
So this order was before Justice Sharma.
Yes.
Whether the order of Justice Datto has not been brought before this court.
Yes.
So why, if it is out, how this order can be passed? Okay, then what has happened after this?
After
this order was passed. This impugn order is passed.
Justice Sharma passed the order, below direct the your lordship.
Correct, directing to consider and
page 29.
Page
29, 129.
129.
Accordingly,
correct. That dispose directing to dispose of giving opportunity.
Yes, my lord, the president of the board again heard the said matter and passed the order. Your lordship can see. Page 131.
That is the impugn here.
Yes.
That is the impugn order.
After third
that is challenge here.
Yes, yes.
Correct.
Yes,
that is challenge here.
And my lord, what are, in the meantime, there another writ application was filed by some of the guardians, my lord. Your lordship kindly turn the page, my lord. 133. In this court, before the Justice Chakraborty. So when it is a purely res judicata arises.
Yes, where is the order?
That is the page 133.
Ah.
Identical issue.
Hmm.
That is the page 133, my lord.
Ah.
The subject matter of challenge in the present institution is an order dated 11th April 2017, passed by the President of the West Bengal Board of Education. Upon hearing the learned advocate appearing for the respondent parties and upon considering the materials of record, I am of the opinion that the matter need to be decided upon the exchange of the affidavit. Accordingly, the respondents are directed to file that affidavit in opposition within 3 weeks, and after Xmas vacation, reply thereto, if any, is filed within 2 weeks thereafter, and let the matter for final hearing in the daily supplementary list of 16th February 2018. The maintainability point raised by Mr. Borua, learned advocate, appearing on for the respondent number 10, is kept open and to be considered at the time of final hearing of the writ petitions. So, my lord, identical issue has been, some of the guardians filed same issue before this court, and court passed an order of filing the affidavit in opposition and reply. Again, they filed these writ petitions here. So, my lord, same identical writ petition was filed, identical writ petition was filed before this court. And, my lord, what has happened was this.
Where is your memo that 2nd September 2004 and 15 July 2014? Page 82.
2nd September 2004, that is the page number 63.
Page?
Page 63 of the writ petition. All, my lord, regarding 5 to 8, not others.
5 to 8.
Only 5 to 8. These 5 to 8, my lord, and other classes are all co-educations.
All?
All co-education schools.
So you are concerned with only 5 to 8.
5 to 8.
So you are not extended till 11, 12.
Because, my lord, 11 to 12, because there is order of the court. So, my lord, I have to follow the order of the court.
Okay. That's all.
And, my lord, and they have not challenged the order of 150. That is the main order, my lord, of the board. That is a circular. They have not challenged.
Circular means?
Circular means the page, my lord, 61. Page 61, the circular. That is 16 July 1956 circular. This circular is still subsisting.
No, that is still.
That is within 31 kilometer. There should not be any girls' school near the co-education school. So, my lord, if they allow the co-education school, then, my lord, all the girls students, if go there, school, and the girls students will be, my lord, all there should not be, school will be vacant.
So, but you have only concern with the 5 to 8.
5 to 8.
And your girls' school only 5 to 8.
No, up to class 10.
Up to class 10.
Yes.
But here is the class up to class 12.
Because I got the order from.
Just a minute. This is up to class 12.
Yes.
So if you are telling that this page 61 and 62 is to be implemented, so you have not opened. There is no other class school in the class 1 to 12. So whether you can say the half is to be taken into a
No.
part is to be taken into consideration, part cannot be
My
taken.
objection is not from 5 to 8. They should not take admission.
Why?
5 to 6.
If
Because
you are
it is
telling
not
that,
ordered
if
before.
you are telling that your school is up to class 10,
Yes.
correct, and you are harping upon page 61, 62, the co-education notification,
Yes.
correct. So you are telling that you are harping only with regard to class 5 to 8, but your school is 10,
Yes.
up to 10. You are not asking to 8, 9 and 10, and they are having
My school is purely girls' school.
purely girls school, but your case is only up to class 8.
5 to 8.
That's why up to 5 to 8, 5, 6, 7, 8, 4 classes. So if you are telling that, so how whether as per your submission, this page 63 is to be implemented part.
63 implement. Below 63.
Kindly come to the page 62. If you go by the page 62, clause 5,
Yes.
so no school can be within 500 meter.
Yes.
Correct. Girls school cannot.
The order of the board.
That's why order of the board. If the order of the board, so you are telling that you are only concerned with the 5 to 8.
Yes.
And the co-education is 5 to 12, 1 to 12.
Yes.
And they are admitting. Why only you have chosen these 4 classes?
Previously, court passed this order. So I have come before.
No, court passes the, because court passes the order in terms of your notification of 2nd September 2004.
September 2004.
Yes.
Of the 2nd
So
September.
that's why 2nd September 2004 only relates to class 5th to 8th.
Yes.
5th to 8th.
Yes.
So why you have chosen only 5th to 8th?
50 because because my lord, it was passed, my lord.
Because as per your submission, the girls school having up to class 10,
Yes.
1 to 10.
Yes.
It is you are not get that the 1 to 10 no girls students should be admitted in the co-education school. Correct. You are only with regard to the 5 to 8.
Yes.
Why only this part you have chosen? So whether this page 62 clause 5
Previously,
will give an effect of part effect.
Previously, my lord, it was up to class 8. As a previously, it was up to class 8. 8 class 2. At that material.
Okay, 8. The 1, 2, 3, 4.
1, 2, 3 is a one. It is a my lord, junior high school called my lord, junior high school up to 5 to 8.
Correct. But that
So,
your girls school is.
Thereafter, my lord, the girls school was upgraded as a class 10.
Okay. Okay. That's all.
So, my lord, and at the same time, my lord, they have, my lord, not challenged the order of the Justice Dipankar Datta as well as Justice Dipankar Datta's contempt application. So, my lord, these order passed by the Justice Dipankar Datta, I have to follow the order passed by Justice Dipankar Datta.
So what has happened to this writ petition? WP 2458 Justice Chakravarti has passed an order, which
Yes,
page
my lord, that is
133. Huh?
Still pending.
Where it is?
It is in this court, in this court. In this, because my lord, it is still pending.
Still pending.
Yes. So, my lord, they cannot because my
In
they
which
could have
court it
filed
is pending?
This
Which court this writ petition is pending?
at that material time the determination was Justice Kapoor.
That's now where is it is?
I am the writ petition WP number 24581 W 2007.
Okay. So it is still pending.
Yes. So, my lord, the question of res judicata arise when
How res judicata? That's why I'm asking.
They could have filed an
If it is
application
pending, where is the res judicata?
My lord, if I could have filed an application for addition of parties in this case.
That's why I'm telling this has not been disposed of.
Yes.
If it is not disposed of the res judicata. And Mr. Sanyal, your client has not challenged the order of the. Kindly come to the page 100.
Justice Dipankar Datta's order need not be. I explain your lawsuits why. My lord, if your lawsuits change, see the change of events. Every writ petition was moved by guardians. By up to 2017, 18, 19, all of them admitted. Even before lawsuit Justice Datta's order, there is a contempt.
No, there is contempt. There are
That's
again,
what their purpose was served, those parts guardians.
Correct.
So did not proceed with the writ petition.
Correct.
Like 2017 referred to before the Justice
Chakravarti. Subsequently, this is the mandatory order of Justice Datta.
No, I tell you lawsuits, it's not mandatory.
Kindly come.
I get your lawsuits.
Page 100.
Page 100.
Yes.
Page 100, your lawsuits will find. Page 100, just
page 100, last paragraph, but one. However, the authorities of the said Sikshayatan shall not admit any new girls student in any class henceforth. It is made clear that notwithstanding the arrangement to be worked out by this order, W shall be at liberty in the interest of education national locality shall take. So this is mandatory.
I take it. Kindly take your lawsuit, page 100, last paragraph.
Yes, I am there only.
It is made abundantly
prior to
clear.
that,
Get your lawsuits. But these qualified by the subsequent paragraph. Kindly see. Even the Justice Datta's mind was curious. You cannot do it. It is made abundantly clear that notwithstanding the arrangement to work out by this order, because I tell you, lawsuit first moment, there are girl students who were already studying. They came up.
Correct. Now, yes.
The West Bengal board shall be at liberty in the interest of education of students of the locality to take further decision that might be necessary, including review of the decision.
Correct.
So we approach because of this before Justice Sharma. Look, this is violation of fundamental right.
So,
and I tell you, lawsuit, this is
so thereafter,
Justice Topoboto.
No, kindly come to then page 113.
113.
Page 113 in the contempt order.
Exactly. And contempt, what happened to your lawsuits? There's further admitted without review of the decision. Then, therefore, there was a contempt. Even then, court said no, those students will continue. No further.
Page 112. paragraph 8, in which I direct the admission granted 33 students regularized, and it is made clear that with effect from the next academic session, the authority of the so-and-so school shall not admit any new girls student.
Shall not, your losses.
Admit any new girls student from class 5 to class 8.
Exactly. They have not admitted thereafter.
Correct.
Now, what happened, your lordships? This is the order in the contempt. This is not the judgment. This is compliance of the order, whether you have admitted or not, that extent. Now, ultimate order says board has to review its decision. So, therefore, this is a question of fundamental right. First, your lordships, there cannot be any limitation or waiver on the fundamental right. This is the basic principle of law. Second, your lordship, my learned friend is clamoring about res judicata.
No,
all the petitioners are different.
That's correct. The court has given a liberty, but they have not done so.
This is illegal. That is illegal. That's illegal. They have failed to decide it.
Okay.
For that, my fundamental right will not go, my lord.
Okay.
Your lordship has to deal whether the ultimate decision is correct or not.
And what about this writ petition is pending?
That's what I tell you, lordship. That has become infructuous because those students have also gone out. What would be happen, my lord? Because each writ petition was moved by separate set of guardians because of the subsequent years. This cannot be treated as res judicata at all. Parties are different. There was no decision in the point of law. This is a constitutional mandate.
Okay. That's all.
That's my submission, your lordship.
Yes.
One thing, Your Lordship.
You are appearing for?
I think for West Bengal Board of Secondary Education. Board is an authority.
Correct.
It is the prerogative of the authority to decide to grant a school a recognition, boys' school status, a girls' school status, or a co-education. And kindly come to page 12 of the petition, paragraph 6. Well, kindly come once.
Yes. Paragraph?
At page 12 of the petition.
Yes.
So, my lord, here it states that at least 8 co-education schools are in the said block. So, these are all co-education schools. One girls' school where the petitioner does not want to take admission, and this is the only one boys' school which board wants that school to remain a boys' school. So, my lord, some students or some candidates may want their wards to get in a co-education school as per their choice. There are a total 8 co-education schools in the total area. One boys' school, one girls' school. Their lordship, there may be some guardians or student boards also who want to get their wards to be admitted in a boys' school. So, my lord, there will be no option of a boys' school. There are ample co-education school in that area. Anyone wants to get admitted in a co-education school, there they can go.
But even though it cannot be taken as a boys' school, because you have taken the decision only class up to 5 to 8. What about the other classes?
No, now, thereafter the lordship, the board has decided that directed the school not to admit any girl student. Thereafter,
Girls student with regard to 5 to 8.
No, thereafter.
Not kindly.
Yes.
Where is the total banning of the admission of the girls student? There is no total banning. 5 to 8 only.
Well, that class 8 school. Thereafter, subsequently.
8, but okay.
So, well, the last decision of the board, that decision is clear, Your Lordship, that not to admit any girls' school. Well, in the total area in this particular block, there are 8 co-education school, 1 girls' school, and one boys' school may remain. So the guardians or the wards who wants to get admitted in only a boys' school, not a girls' co-ed school, my lord, they will have no option.
Yes. That's all.
Lordship.
May I deal with this submission?
This is administrative decision of the authority, the education department. It is not only the board who takes the decision, it is the total education department who takes a decision and accordingly board takes it.
Okay. Yes.
But point wise, just your lordship. My lord, co-education school was from the very beginning. For subsequent recognition of girls' school, one cannot be made co-ed. First. Second, your lordship, my first paragraph 6, your lordships will find these schools within a radius of 4 kilometers, all co-education. If a guardian's choice is that the co-education which was originally granted, that was better than the other schools, my lord, on constitutional tenets, I cannot be prevented.
Correct.
That's your lordships.
Okay.
Was the choice of the others, that's the constitutional, not tenets. You have the option of the schools. This cannot be said by the board in 2025. 2025, they cannot say some guardians wants their school only with the boys, because this is against the inclusive education. That's why I have shown to your lordship the Supreme Court judgment. This very conception of the board is wrong and unconstitutional.
This 155,
And
1955 circle is not
Yes.
And 1965, I tell you, lordship, that's why I've taken you lordships to Justice Karju's judgment. They wanted to implement similar circular. Karju, the Honorable Justice Karju said, it is ex facie unconstitutional. If I bring something to the knowledge of the court that based on this certain orders were passed, but if it is ex facie unconstitutional, no argument is required, then your lordships can do that.
Yes.
This is based on sex, simply on sex. And for some bodies, I tell your lordships, some school will reduce its admission. Is it a ground? Is it a ground, your lordship, in the board's order that the boys will be deprived? That's not the ground. That's not your ground. Kindly see all the orders. That particular school is decreasing their strength. If decreasing their strength, you have no capability to survive. Existence crisis because of downgrading the role strength. This is your problem. Make that school also co-educational one.
Okay. That's all.
That's all, your lord.
Hearing concluded, CAB.
Lord, the interim order, your lordships, kindly for the.
What's the interim order?
The till today. Interim order was, your lordships, the admission kept open to that. Admission language the key chulam exactly. Not to admit the students. Because if the students are admitted, girl students will be deprived.
No, there is no such order.
Oh, admission date was extended to that extent, so that it remains existence.
There is no such order.
Distribution of the admission form. Still, admission is going on.
Yes.
No, only simply date extended, nothing has been done. Because if I have also had to apply. Unless your lordships extend it till the delivery of the judgment, I will be going out of that.
Hearing concluded, CAB. Interim order is extended till the disposal of, till the final order.
And
Till the final order is passed.
Lordship, why not one compelling circumstances when I'm mentioning this matter? The petition is in custody, his detention, the sentence has completed by the which was imposed by the learned judge, trial court. Your lordship has held this matter, that the pushback policy of the is the Bangladeshi national, that your lordship knows that manner. Your lordship further directed to us, provide the address to the learned ASGI as well as the state. We have provided, they are supposed to verify, they are supposed to file the report, Today is the returnable date, unfortunately, matter is not coming. If your lordship kindly keep this matter Monday, we shall do it. He is in excess 50 days in his detention in custody.
Which matter? Where is your
This is the next one.
score? 22nd. 22nd January under the
Lordship,
agenda.
I want to mention regarding item number 30. Lordship, kindly fix it on 27 January.
Item number
30.
30.
Fix it on 27 January, Lordship.
27
January.
27.
Because I will have to go to my native village for the puja.
Page item number 27.
Item number 30, 27.
Item number 30. We got. As per the prayer made by the counsel for the petitioner, let the matter appear on 27 January under the same heading.
Grateful.
make a joint prayer. I spoke with Mr. Mukherjee. Malad, could it be next Thursday and Lordship will give us any time like Lordship did, a 1 hour slot?
Time you will get, then you come to March second week.
No, my lord, we are suffering an entry mode.
Then it will remain in the list whenever the time.
No, my lord.
Want any time?
Lordship.
Then it will go to the second week
No,
of
no,
March.
Lordship, I'm making this request on behalf of my other side.
Correct. I I
Lordship.
accept all requests,
Lordship.
but my diary doesn't.
If your lordship
find any
if your lordship diary permits, then kindly
Only,
will not.
my lord,
Because
the
Mr.
only
Mukherjee
problem
has
is
some
what Mr.
difficulty on
Mukherjee,
Monday, Wednesday, and
my lord,
Tuesday.
Mr. Mukherjee told me that he's actually being a part of the High Court mediation, which is to take place from Monday to Wednesday. That is the only problem. Otherwise, there would be no problem. Lordship. It's just a High Court event.
Then I will fix some. No problem. I will fix some.
My lord, because our interim order, Lordship, by the division bench is till 31st January. My lord, it's only till 31st January.
No problem. By that time, so I am when Mr. Mukherjee
Any
will
Thursday,
agree.
Next Thursday, Lordship.
Thursday is 22nd.
22nd.
Subject to my lord's approval.
22nd.
Only about half an hour's hearing is left.
22nd I can't give the time, but I can. 22nd कितना है? Motion में, urgent में, बहुत है.
Well, just a half an hour slot would be enough. I'll cut short my submissions also. I would take 15. I'll take 5 minutes if necessary.
Item number 7. As per the prayer made by the council for the parties, let the matter appear on 22nd January 2026 at the top under the heading urgent motion.
I'm grateful. My lord, most grateful, Lordship. Most
Yes.
grateful. Great time.
Call the fixed matter.
May I take your lordship's back to my lord, this page 76.
76 of this
Compilation, my compilation.
Yes.
This is the food safety and standards, food product standards and food additives regulations 2011. But these regulations have also been made under in exercise of the power conferred under section 92 2E 76. So, my lord, if your lordship can take your lordship through 2.2, which is at page 77. Well, I have not the entire regulations are not before lordship, but my lord, only the relevant excerpts, my lord, subject to lordship can. Well, 2.2, your lordship will find under the head 2.2, that is fats, oils, and fat emulsions. Your lordship will find the first category is 2.2.1 oils. Now, my lord, kindly come directly to page 78. And if your lordship takes regulation 2.2.1, clause 24.
Yes.
This is multi-source edible oil.
Correct.
Means an admixture of any two edible vegetable oils where the proportion by weight of any edible vegetable oil used in the admixture is not less than 20%. The individual oils in the blend shall conform to the respective standards prescribed by these regulations. Multi-source edible vegetable oil shall not contain more than 33% of saturated fatty acid. Multi-source edible vegetable oil may have an ideal ratio of omega-3 and omega-6 to be in the range of 1:5 or 1:10. The third oil, named chia oil or flaxseed oil or linseed oil, up to 5% of total oil may be added if the multi-sourced edible vegetable oil is claimed to have an ideal ratio of omega-3 to omega-6. The blend shall be clear, free from rancidity, suspended or insoluble matter or any other foreign matter, separated matter, added drink coloring matter, flavoring substances, mineral oil, or any other animal or non-edible oils or fats, argemone oils, hydrocyanic acid, castor oil, and tricresyl phosphate. It shall also conform to the following standards. So, my lord, your lordship will find till date blending of, Bevo with mustard oil is permissible in terms of the regulations.
Yes.
But what is most important is that if your lordship kindly takes this clause 24, your lordship will find that blending requires high technical expertise.
Correct.
Right, my lord? Now, my lord, kindly take along with this, kindly come back to this, kindly come back to page, yes, page 320, I'm sorry, 86, 85. This is the scientific panel recommendation. This is very interesting.
The panel noted the government of India issued a direction on
Yes,
23rd
my lord,
September.
I am on paragraph 3 at page 386. I'm sorry, 86.
86.
Compilation. Yes, kindly take paragraph 7.
Which is at page 87.
Which is at page 87.
87. Paragraph 7, 87. Yes.
First 3, then 80, paragraph 7. First paragraph 3. Those in favor have broadly argued that they prefer pure MO to be available in the market, permitting blend.
Which you are ready?
I'm sorry, my lord, this is page 86. My lord, the recommendations or comments, serial number 3, paragraph 3.
Yes.
The last column. My lord has got that?
Yes, yes.
Those in favor have broadly argued that they prefer MO to be available in the market, permitting blending leads to possibilities of adulteration of MO, and that consumer should have a choice of whether they wish to blend oils or rotate different single oils. So this is one aspect. Kindly along with this, kindly take paragraph 7, which is at page 87. The panel is of the opinion, also of the opinion, that it is still open to the consumers to either blend edible vegetable oil or to rotate consumption of various vegetable oils in their own level.
Correct.
So, my lord, they are, when the law requires technical expertise for blending edible vegetable oils, the scientific panel says they are leaving this option open to the consumers that they can blend in their respective households.
Yes.
This is completely irrational, completely antithetic to the, my lord, the regulations of 2011. And, my lord, there is no risk analysis management.
So panel is recommended only for
So they say that
edible.
it is still open for you as a consumer. You can blend, but I will not allow blending on a large scale basis when the blending would require the technical expertise as provided for in clause 24 of regulation 2.2.1 of the food standard and food additive regulations.
Yes.
Food products and food additive regulations. So this is one aspect. Now, my lord, I take your lordship to the meat of the matter. Now, my lord, what happened? What were the regulations prior to amendment and after amendment? That your lordship will also find in the compilation itself. Kindly take, my lord, my compilation, and if your lordship takes, my lord, pre-amendment, that is at page 56. Well, I will stand corrected by Mr. Kundalia. If there is some typo, there is something, I will stand corrected, my lord. My lord will kindly take page 56. This is food safety and standards prohibition and restrictions on sales regulations 2011. But these regulations have been made in exercise of the powers conferred by section 92. Now, my lord, kindly take 2.1.
Sale of certain.
Sale of certain admixtures prohibited.
Yes.
My lord, it ends at serial number 10. The last entry being milk or milk products. Well, it begins with notwithstanding the provisions. This is very important. Notwithstanding the provisions of 2.7 of labeling and packaging regulations, no person shall either by himself or by any servant or agent sell. Then Miller kindly take serial number that at the end of the Miller this series of products, your lordship will find serial number 10, that is milk or milk product specified by the food safety and standards, food product standards and additive regulations containing a substance not found in milk except as provided for in the regulations. Remember, these were the regulations that it stood prior to the amendments so made in with effect from March 2021. This is prior to March 2021. When an attempt was made to issue an order under section 16.5, that order was withdrawn. Now, now I kindly take the post amendment, that is the regulations as it stand now. That starts at page 65.
Yes.
Lordship will kindly take, notwithstanding the provisions of 2.7 of labeling and packaging regulations, no person shall either by himself or by any servant or agent sell. After 10, your lordship will find 11 at page 67. This is the insertion made by the rule making authority.
Up till 10th, it was intact.
Intact. There is no. We are not concerned with up to 10.
Okay.
What we are concerned with is
Provision.
that insertion of serial number 11
Correct.
or item 11, if I may say so. Multi-source edible vegetable oil containing mustard oil manufactured on or after 8th June 2021.
Manufactured on or after, yes.
8 June 2021. But this is very interesting, my lord. Your lordship will find these regulations, this prohibitory provision contained in chapter 2 of the regulations begins with a non-obstante clause. Your lordship has seen that?
Non-standing, yes.
Notwithstanding it, the provisions of 2.7 of labeling and but it is not. There is no non-obstante clause in so far as, my lord, food products and food additive regulations are concerned. So, my lord, kindly look at, my lord, the absurdity of the situation. The absurdity is such that yes, there is a non-obstante clause which takes care of the labeling and packaging regulations, but there is no non-obstante clause with regard to the, my lord, food product and food additive regulations, which still permit me to manufacture, my lord, bevo with mustard oil in it. The non-obstante clause is a limited non-obstante clause, if I may say so.
Why?
It is limited to the notwithstanding the provisions of 2.7, only the labeling and packaging regulations, not, my lord, the food products and food additive regulations. Could I make myself clear, my lord?
Got it.
Grateful to your lordship. So your lordship will find this is the insertion. Now, my lord, I come to the meat of the matter. But may I just categorize my submissions now? The amendment made by the FSI in exercise of the power conferred under section 92 of the Food Safety Act or Food Safety and Standards Act, my lord, is irrational, arbitrary and discriminatory, offending Article 14 of the Constitution of India.
Why?
Why, my lord? Because bevo with all other kinds of oils is still permitted, and there is no rational nexus as to why bevo with mustard oil now stands excluded or banned.
Correct.
My lord, bevo with, my lord, say linseed oil, with rapeseed oil, with, my lord, say for example sunflower oil, everything is now permitted, but except with, my lord, this mustard oil as its ingredient is banned. And
what is the reason given that?
The reason, there is no reason given there. The reason is that your lordship would have to look at the scientific panel recommendations. Your lordship will also look at the report filed before in terms of the report filed by the committee constituted by the ministry. Your lordship will find the first reason is that it is better to promote the production of mustard oil in India. It is better to have pure mustard oil in the market. There is a hint that this kind of blending may encourage adulteration. But I made myself clear. the paragraph 8.6.4 of the report or 8.6.5 of the report which I will placed, it only says that 23% of mustard oil in Delhi market was found to be adulterated. Mustard oil, my lord, it's not a question of Bevo. There is no allegation whatsoever in any of the reports that none of the manufacturers who are manufacturing with Agmark registration have indulged in the practice of, my lord, this adulteration. There is no allegation whatsoever. The reason, simple reason is that it is better to have pure mustard oil. Like Italy and Spain has pure olive oil, we should also have pure mustard oil. That's the whole rationale behind this particular regulation. Scientific panel says that yes, the blended Bevo with mustard oil has certain, my lord, added advantages. But since it is a diktat from the central government, I have to make these regulations, I have to make this recommendation.
Yes.
My lord, I take your lordship once again, my lord, I would be harping on this time and again. My lord, I take your lordship once again to paragraph 80, page 82. My lordship will find from the report, before I take your lordship to the paragraph 82, lordship will find from the report the views of the ICMR, the view of the National Institute of Nutrition, none of the authorities who are, my lord, scientifically distinguished, who are having the expertise. But I am not an expert, my lord, but they are the expert. They don't say, or they say in no uncertain terms, if I may use the expression, that yes, Bevo with mustard oil has certain added advantages. Now, my lord, kindly take, my lord, the scientific panel report, which clearly says, my lord, kindly take paragraph 8, page 87. Well, it is clear, my lord, the language is so clear, my lord. Page 87, this paragraph 8 or serial number 8 in the report.
And this is taken as the opinion of the panel.
Yes, my lord.
Panel is of the opinion that it may be finalized as it is a direction.
Yes, my lord. Now, my lord, the last part, as it is, kindly take, my lord. I'm sorry, my lord, I should have taken your lordship through the entirety. The panel is of the opinion that it may be finalized as it is a direction from the government and in the larger interest of discouraging adulteration in the name of blending, rather than on the basis of specific scientific rationale.
Correct.
In view of the above, the panel accordingly recommends the draft recommendation for notification, for finalization that involves further approving, and also recommends giving sufficient time before it is made effective, as the draft states that the amendment would be effective from 1st October 2020. Lordship may kindly, I would beseech your lordship to kindly just take note of the fact that the 16.5 order was the first order in this series of actions taken by the central government and FASAI. 16.5 order was issued by FASAI at the instance of the central government. 16.5 order was withdrawn because one petition was pending. I am not on that. And, my lord, in the meantime, they brought about the draft regulations. Draft regulations were open to my lord, scrutiny, and obviously, my lord, invited suggestions or comments from the stakeholders. It happens that about 400 odd stakeholders opined that no, it is good that Bevo with mustard oil should go. Reason being, not adulteration, pure mustard oil. 22 or 23, I am not giving the exact number, your lordship will find in the panel itself. There was a representation along with the association that Bevo with mustard oil should continue, and the rationale was given by the Solvent Extract Manufacturers Association. The scientific panel, if your lordship kindly takes the report of the scientific panel, kindly take paragraph 5 at page 82.
So before going to now the clause 8, page 87.
Yes.
The panel is of the opinion that it may be finalized as it is a direction from the government. So this is first condition they have taken into consideration, the government direction.
Right.
Correct. Direction from the government, and in the larger interest of the discouraging adulteration in the name of blending.
Right, right.
So where from this got?
I'm taking your lordship to straight away. Straight away come to my lord. This page, just 1 minute, 8.6.4. Yes, page 14 of the compilation. 13 and 14. This is the only data, this is only empirical study regarding, my lord, this adulteration. I could not find any. My lord, my learned friend could find something more. My lord, I will then make submissions if they find something more from the available records.
Committee for the deliberate.
My lord, may I just read out? My lord, subject to your lordship's kind sanction. The committee further deliberated on the issue of adulteration in edible oils. Food adulteration is the addition or removal of any substance to or from food that the natural composition and quality is affected. Adulterated food is impure, unsafe, and not wholesome. Food Safety and Standards Act 2006 defines adulterant as any material which is or could be employed for making the food unsafe or substandard or misbranded or containing extraneous matter. The committee was informed that edible oil survey carried out by FSI in Delhi NCR in 2019-2020 brought out the fact that 23% of mustard oil samples failed on account of adulteration. But this is mustard oil, this is not bevo containing mustard oil.
Correct.
And my lord, what is the sample survey? One unit state,
Delhi. So
and the entire ban imposed on the basis of this sample survey. This is the empirical study which, my lord, this committee refers to in its report. I could not find any other material regarding any empirical study carried out by any competent authority justifying the prohibition of use of mustard oil as an ingredient in bevo.
So this is the report of which date?
My lord, this is the report of, my lord, I'm giving your lordship the dates. I'm sorry, my lord. Kindly give me 1 moment. This is the report of, but this is the report subsequent to, this is the report of May or June. Sorry. Nah, this is the report of, no, my lord, not May. The committee was constituted on 27th May. The constitution of committee, your lordship will find on June. My lord, my learned friend appearing for FSI will be able to tell the date of the report. It must be August or September, subject to correction by my learned friend.
That's why if it is a June,
it is not June, my lord. It cannot be June, my lord, because I tell you, your lordship.
So, and this recommendation, when is the recommendation?
My lord, the recommendation, the scientific panel recommendation. My lord, the scientific panel recommendation, my lord, subject again correction by my learned friend, was considered in this report, subject to correction. Well, I will stand
for this report. The scientific
my lord, it may not be so. This report initiated the process of, my lord, issuance of order under section 16.5.
Correct.
Thereafter, when 16.5 order was issued, then, my lord, the regulations were made. Draft regulations were made. 65 order was withdrawn. So this is prior to October 2020.
That's because why?
I absolutely, my lord, I stand corrected.
My lord, if my lord sees page 80. 80.
80.
80.
In 80.
80.
My learned friend writes, the
Pursuant to
council
the
for
order
FSC.
dated itna pass by the honorable website, copy of the minutes of first meeting of scientific oil.
Held on 29th January 2021.
No, this is
no. This is the scientific panel.
Yes, scientific panel.
No, I'm talking about the main report.
Now, if my lord sees.
Now, here the three things is to be considered.
Right.
This is the first report.
This is the first report.
Scientific panel report.
This is the subsequent report. Right.
Correct. Subsequent. If the before scientific, whether how this committee has come to the conclusion.
Yes, my lord, this absolutely, my lord. I bow down to your lord. I could not have put it in a better term.
That we will give an answer to.
I could not have put it in a better
term. That's why I want the date. if this scientific committee is after
Yes.
and this meeting is prior,
Yes,
report
absolutely,
is
ma'am.
prior, so how this page 14 conclusion has come?
My lord, if my lord sees the index
Yes.
of this report, the first page of the report,
20th September 2020.
which one?
This report, this is report of the constituent of the committee constituted.
It's a page,
Page 44.
page 44.
44. अच्छा देखी
Page 44.
My lord, see it's page 44.
Correct. 2002 report of the committee constituted to examine the issue relating to the blending of vegetable oil, BEVO. So this is and Dr. Fasai so report of the committee. This
but report must be in September.
No, you are referring to this report.
Right.
He's referring to this.
that is 46. Not 46. You come to this first one, page 8.
Page 8, page
Starts from page 8.
page 7, my lord. Page yes,
From page 8.
page 8, correct, my
And
lord.
the consideration is page 14.
Right, my lord.
Consideration is page 14.
Correct, my lord.
May I just point out, page 7, my lord, is the first page of the report, where the index is there.
Right.
Your lordship will see there is a report for pages 1 to 9. I mean, all of it is there. This is page 7, my lord. Report at page 1 to 9 and annexures there too. Now, your
1
lordship
to
will note-
9.
Yes, my lord. So it continues after this. This is internal page 1 to 9. But my lordship will see the report annexes all the things that led up to the report. So my lord, first of all, it shows the meeting held on 27th May. You will see item 2 on page 7, my lord. Thereafter, my lord, there was an order to constitute the committee at page 3. This is item 3 on the same page. Now, my lord, these orders, I'll show you. Your lordship will see. My lord, the first minutes that it refers to of May is at page 16 of your compilation. We are on page 7. If you go to page 16, is annexure A.
27th May.
27th May.
Correct.
Thereafter, at that meeting, is decided to constitute the committee. Thereafter, the committee is constituted via a notification, my lord, which is on the next page. Sorry, my lord, on page 21.
Page 21, blended edible oil.
This constitution of committee.
21.
So this is item 3 on page 7, my lord.
Just a minute. Page 21.
This is item 3 on page 7, my lord.
Blended edible vegetable oil, grading and markable. That's a rule. 21 to 20, that is a rule. Kindly come to the page 21, that is running page 27.
Right.
No, my lord, I'm talking about on top, my lord. Page 21 of the compilation itself.
21 of the compilation.
Yes, sir. I'm giving you the page numbers of the compilation for your convenience, my lord.
Correct.
So page 21 is item 3 on page 7. If you go to page 7 of the compilation, that is the index of the report.
Constitution of committee.
Yes, after that, 2 meetings are held by this committee after constitution.
Just a minute. So then you have to go by date. Correct. The first when the committee was constituted. This is of which date?
Well, the committee was constituted on 12 June 2020.
12th June 2020.
20. The meetings were held in the month of July 2020.
Page 21. Page 21 is the constitution.
Yes.
It is also there at page 5, my lord. It is also there at page 5.
That's part of the report.
Yes.
So this is a dated.
So this is. My lord, I think 12 June, my lord. As per the index that
12 June. 12 June.
12 June.
This is from their affidavit. This is from the affidavit of Fasai.
So this, because first the committee will be constituted.
Right.
Yes, ma'am.
So this is 12th June.
Yes, ma'am.
Correct. Page 21.
Lord will know this is a committee constituted by the Ministry of Health and Family Welfare.
Correct.
This is by the ministry.
Ministry.
Then, my lord, 2 meetings are held by the committee. My lord, on 4th of July and 8th of July.
8th of July.
The lordship will see on page 22 are the minutes of the meeting held on 4th of July.
Correct.
Then, my lord,
First meeting.
At page 24, my lords, is the minutes of the meeting held on 8th July. Second meeting.
The second meeting.
Now, at that meeting, my lord, after that, this report is prepared, my lord.
Second meeting is 8th of July.
Yes, my lord.
Correct. Then what has happened after the second meeting?
Then I'll tell you, my lord.
Huh?
My lord, then if your lordship comes to page, which page were we at again?
44.
44.
44, yes. 44.
The date of report is not available, but my lord, it is referred to in the
The cover letter. Now, my lord, if your lordship sees this is the ministry. Now, the ministry writes to FSSAI asking for action to be taken on the report. That is at page 44, my lord.
this is September, as I was saying.
So, this is in September.
23rd September.
23rd September. 2020.
24, 23rd September.
my lord,
So second meeting was 8th of July.
Yes.
2020.
Yes. After
And
that,
this two meeting, after the two meeting, then it was given to the food safety.
Yes, my lord. Now,
Government has forwarded to the food safety.
Yes, my lord. Now, lordship will see, it says, my lord, there's a report that has been prepared. FSSAI is therefore requested to take necessary action as per the act. Now, under the act, my lord, I am supposed to refer it to the scientific committee, which I do. So, therefore, the scientific panel, my lord, considers the matter. When it comes to FSSAI from the ministry in September, that is when I give it to my scientific panel. The scientific panel considers the matter.
That's where is the when scientific panel was taken into consideration.
Yes, my lord. I'll just show you.
46.
My lord, may I just show you, my lord, two things prior to that, my lord.
My lord, that is 21st January 2020, 29 January 2021.
After that,
if I may show your lordship, my lord, if your lordship comes to, my lord, just show your lordship. The draft regulation also.
Must be in the affidavit.
That is there. Draft regulations are here, actually. Page 49. The lordship will see page 49.
Yes.
My lord, this is the draft regulations are published for public comments. So, my lord, public comments are called for. Now, these public comments have to be sent to the scientific panel, which is what it considers. So, your lordship, this is on 10th November. Your lordship will see 10th November 2020.
Page 40?
Page 49.
Page 49.
This is the draft regulations are published. The lordship will see on page 50, right at the top, objections or suggestions, if any, may be addressed to the Chief Executive Officer, Food Safety and Standards Authority of India, and sent on email, etc., etc. Then it says objections or suggestions which are received from any person before the expiry. Now, my lord, that expiry, that is, I think, a period of 3 months, I think, 60 days. Sir. On the prior page, second last sentence, on page 49, 60 days. So, 10th November, this is published. The period of 60 days is given for public comment.
Correct.
Now, my lord, after that,
Public comments, etc.
then, my lord,
20th January
comments are received, which are considered by the scientific panel. My lordship will see on page 81.
Reported date diyeche video.
81, my lord. So, my lord, 10th November, 60 days. So, about, let's say, 10th of January, comments are supposed to be received. Page 81, my lord, is where the scientific panel meets and considers these suggestions.
21st of February.
Yes, my lord. And the annexure that my learned senior was showing you on behalf of the petitioner, that annexure, which is the comments of stakeholders, which is what was received, the public suggestions, that starts at page 85.
Correct.
So there they say, my lord, your lordship will note that it goes through what comments have been received. It gives its recommendations.
No, this has been taken into concern all. With
Yes,
regard to the organization, comments, reasonable and panel recommendation.
My lordship will see at page 91. It gives the, my lord, it takes into account 5 or 6 different comments which have been received against the ban, including by the Solvent Extractors Association, which my learned friend is part of, or learned friend's client is part of. After that, my lord, it notes that lordship will see there is comment received in support of the draft notification. So first, the table deals with all the things against the notification. Then it deals with what is for the notification. What is in favor of the ban. Then it says, my lord, it says, in addition, approximately 487. I'm looking at the second paragraph. In addition, approximately 487 comments have been received in support of prohibiting blending mustard oil with the following rationale. So first, it deals with all objections, including my learned friends, Solvent Extractor Association's objections. Then it talks about who have given views in favor of the ban. And thereafter, my lord, it comes to a conclusion. So, my lord, that is the order. So, the ministry sets up a committee. They consider it. They give it to the FSSAI. The FSSAI sends it to publishes a draft notification. Public comments are called for. Comments are sent to the scientific panel for consideration. Scientific panel agrees that it is okay to ban in wider public interest. because of adulteration. And then, my lord, finally a notification is issued, my lord, in March. After this is 29th of Jan.
No,
Then, my
that's
lord, the final notification of the regulations.
That's correct. Okay, as per your this is the last one. Page 91 is the last one, suggestion of the
Yes, my lord.
scientific.
After that, it comes to the FSSI with the suggestions. A notification is published by the
Publish the
FSSI on
noti-
8th of March 2021.
Correct, no problem.
After
But
following the process.
now again the question is, now kindly come to page 8, page 14, page 8. How this report was prepared? After that, after receipt of that?
No, my lord.
Ah.
I'll explain, my lord. This is a consideration by the ministry.
So how when the ministry was considered this?
Yes, my lord. That's what I'll just indicate, my lord. The ministry, my lord, firstly, FSSAI's job is only, my lord, the scientific panel looks at only the scientific aspect. Whereas the ministry and FSSAI have to look at other aspects.
Correct, no problem.
My lord, this is what the ministry first says.
So when it was?
So read this entire report, my lord. That starts at page 8. That is the report by the ministry.
When this report was prepared?
Sir, this report is prepared, my lord. It is submitted to FSSAI on 23rd September. That, my lord, was at page 44. So first the government and all government bodies consider it. Then they send it to FSSAI with its view. Then FSSAI considers from a scientific perspective and comes to the same conclusion.
That's right. Scientific, then again, scientific has concluded page 91. Kindly come to the page 91. That is the conclusion of the scientific.
That's right.
Correct. Scientific, then it has been sent to the ministry for consideration and approval.
No, my lord. After that, FSSAI scientific panel approves it and
Correct.
FSSAI passes the regulation.
Correct.
We are the rule-making authority.
Correct.
So then,
So that's when this report, page 8 was prepared.
my lord,
What
it is
survey?
prepared between July and September.
Where, how you can,
My lord, because it is
how you can
purported-
establish that?
I'll show you.
Because the only consideration of this court, kindly page 14, how this has come to the conclusion.
Page 14. My lord, page 14 or perhaps, my lord, page 15 perhaps.
মিটিং হয়েছে জুলাই মাসে
Recommendation of the committee discussed and decided on the issue.
তারপর মিটিং হয়েছে জুলাই মাসে জুলাই
So, my lord, this is an interministerial panel which has considered it. If you see the constituents of this committee, who has considered it, my lord, kindly turns, my lord, to page 21. These are the people who have considered the matter at the ministry level first.
Page
21. This is the committee. Who are the members of this committee are the following people.
No, show from page 8.
Yes.
Page 8 se bolo na. It is specified here.
Page 8. It's the report itself states, my lord.
From page 8, the first page of the report.
Meeting chaired by Minister so and so on 27th of May 2020.
Yes.
27 May 2020. Correct.
Was it decided that a committee of senior officers may be constituted to examine the issue of blended edible vegetable oils, especially blending of mustard oil with other oils, and to submit its recommendations, minutes of Annexure A. A committee comprising of the following members was accordingly constituted so and so dated
Correct.
12 June 2020 under the chairmanship of the Officer on Special Duty, Ministry of Health and Family Welfare, to examine the issue and make its recommendations.
So these are the issue raised by the ministry.
Yes, and these are the
And
participants of the
till page 15.
Yes.
These are the issues.
Yes.
It's different discussions that they have, my lord, and then a recommendation is at, I think, page 15, my lord.
Correct. Till 15, this was
Yes.
the recommendation of the committee.
So, my lord, if
This
your lordship comes to the last paragraph on the recommendations, my lord, it says that blending is not bad, but because of the specific issues that relate to mustard oil, then it says, my lord, because of the unique identity in the Indian context, the committee felt the need for putting in place specific regulations by FSSAI to prohibit blending in mustard oil and to facilitate manufacture and sale of mustard oil pure mustard oil for domestic consumption. So, my lord, after this report, if you see at page 44, this is the recommendation of the ministry of this interministerial panel. It is forwarded to the FSSAI, at page 44
No, that's correct. So
for
only
my consideration. Thereafter, my panel considers it and then a regulation is passed.
correct. That is not only with regard to them. That's why I wanted to. So how this recommendation as committee had discussed and decided. So whether this report, page 8 to page 15, whether it is a committee examined. So whether which meeting this are coming.
The committee meetings, my lord, are at page, the minutes are at page 22 and 24. And these are all experts, my lord, top people in their department.
That is a different thing. That will
Department.
make submissions.
The ministry is discussing it, all the experts in the
Yes,
ministry.
we
my
will
lord.
come to that.
This is, my lord, the official and special duty of the Department of Health and Family Welfare, the Director General of the Indian Council of Medical Research, the Director General, Indian Council of Agricultural Research, the Director General of Foreign Trade, representative from the Department of Agriculture, representative from the Department of Consumer Affairs, representative from the Department of Food and Public Distribution, PD, representative from FSSAI. So, my lord, they are all experts, all government bodies. The top people in all the government bodies meet, give a recommendation and say specific regulations are required from FSSAI. The report is forwarded to FSSAI on 23rd September 2020 for appropriate action. After that, my lord, I start my process, which is to issue a draft notification and call for public comments. And once public comments are received, it is forwarded to the scientific panel for consideration.
So your recommendation here it's only with regard to this. You are concerned with the E, Mr. Majumdar. You are
Yes.
concerned with the E.
Yes.
Page 15 E.
Page 15E.
E. Last one.
Yes.
Yes.
So that is the recommendation. Committee discussed the decided on the issue.
Right.
Committee discussed and decided the issue. So this one. So why it has been given? The committee was unanimously on issue of the blending of edible oil. Not bad. That blending has its own sets of advantage. There's no problem. However, considering the limited contribution of the mustard to overall quantum of the blended oil around 15% and its unique identity in the Indian context, the committee felt that the
need for putting in place
specific regulations by FSSAI to prohibit blending in mustard oil and to facilitate manufacture and sale of pure mustard oil for domestic consumption.
That's correct.
So they are moved by the need for purity.
So this is the only question.
This is the only question, but my lord, I'm grateful to my learned friend for placing all the facts on record at CDRT. No. My lord, many submissions have been made. Now let me make my submissions.
No, we have not made any
submissions, my lord. We are
No,
just
one tacit submission.
What has asked for clarification?
One tacit submission has been made. The decision has been taken by experts. I understand that. Well, let me make my position very clear. Well, kindly take for once. I am grateful to my learned friend. Now let me take. Kindly take. I am very grateful. Kindly take the first meeting. There is another missing link in the chain that I will also show. Kindly take, my lord, record of the decisions taken on this on 4th of July, 22. Yes, this is Annexure C, which my learned friend was referring to, that all the experts were there.
Yes.
Kindly take serial number 4. This has all been done at the instance of Ministry of Agriculture, and I will demonstrate that right away. My lord, 4 is advisor Fasai.
Yes.
23. 4 is advisor Fasai, paragraph 4 rather. 4 is advisor Fasai made a representation, who must be an expert, and underline the following points. Serial number 4, 23 barcode, 2021 dekhish.
23.
Well, advisor Fasai made a representation and underlined the following points. The blending of oils did not create any safety, quality, or health issues. Any decision to ban blending oil should be uniform for all oils. As of now, there is no scientific basis concerning safety parameters to ban blend of oil with refined oil or new raw with raw oils. Edible oil survey Delhi NCCR, where samples from 11 districts of NCCR were collected, 23 samples of single sourced mustard oil. This is not blended. Single source mustard oil failed for multiple parameters, including majorly oryzanol, marker of rice bran oil. So, my lord, whatever is there at paragraph 8.6.4, that would be apparent upon the from these comments made by advisor Fasai. This is not relating to blending. This adulteration was not related to blending. This is single source where mustard oil is sold as mustard oil in mustard oil form. So this is one. Then, my lord, kindly take, my lord. It was decided, serial number 9. They invite experts. When I am borrowing the expression from my learned friend. It was decided that the next meeting on the subject will be held on 8th July 2020, where the perspective of ICMR expert and National Institute of Nutrition, another expert, shall also be obtained. Now, my lord, kindly take the next meeting. Yes. 24. Kindly take, my lord. DGFT ICAR, then, my lord, after all this, my lord, the views are actually reflected in the, my lord, the report.
Advisory FSI.
Advisor FSI is there. Then, my lord, kindly come back to the report for once, where, my lord, the opinion of, my lord, this National Institute of Nutrition and ICMR has been taken on record. Kindly take, my lord, page 9. Well, your lordship has seen that the opinion was sought for from
Page 9.
9. That's the main report, not the annexures.
Yes.
Because 4th July says they are referring the taking the perspective of NIN, that is National Institute of Nutrition Hyderabad,
Yes.
and ICMR. Now, my lord, let me just place before your lordship what were their views. Page 9. National Institute of Nutrition Hyderabad presented the following views on the issue. Blended oil must aim to obtain a nearby ratio of saturated fatty acids. This is all technicalities. Kindly come III.
Mustard oil has
Mustard oil has right proportion of fatty acids and there is no evidence of toxicity in its consumption. The National Institute of Nutrition Hyderabad suggested that it is important to obtain right amount of different fatty acids in the diet and avoid excess intake of one group of fatty acids. Then hence, to ensure optimal fat quality, the use of correct combination blend of 2 or more vegetable oil is recommended, so as to ensure that the human body gets all the fatty acids in a balanced form. Thus, by blending different oils, the benefits of individual oils can be combined together. Based on the presentations made before the committee and deliberations made in the committee, the issue regarding blending and adulteration was discussed by the committee. Edible oils form an essential part of the modern diet. These oils also play a role in the important source and energy and provide the diet with many beneficial micronutrients. The demand for edible oils in India, well, this is the view of the ICA, where this NIN. And the next one, your lordship will find, just 1 minute. This is NIN's view. And thereafter, the committee straight away refers to, my lord, the final, my lord, the rationale at page 9, page 15, paragraph 9. Kindly take the reasons. My lord, E is the decision, ABCD is the rationale.
Where? Page 9.
Page 15, I'm sorry, paragraph 9, recommendations, page 15.
Yes.
Your lordship will find that A, B, C, D are the reasons and E is the decision. My lord, A, B, C, D.
Yes.
Blending as per se is desirable and should continue in edible vegetable oil. However, it was felt that mustard oil occupies a unique position in the Indian market, Indian context, I'm sorry. There is a definitive crop identity for mustard oil, and the oil extracted out of mustard has natural pungency, which is closely identified by the Indian consumers, it being a household kitchen product Additionally, mustard oil has qualities of being low in saturated fatty acids and high in monosaturated fatty acids due to blending with cheaper oils with less healthy indices. The price of mustard oil gets depressed further. This has adverse impact on the production of mustard oil. Stopping blending of mustard oil for domestically produced oil would encourage farmers to undertake extensive mustard crop production, which would make it more remunerative. However, the mustard oil is to be exported, can still be blended. Since the mustard oil is inherently healthy oil in terms of its composition, its blending is generally with the cheaper and less healthy oils. Stopping its blending would ensure the availability of pure and healthy oil to consumers. It has been seen under the garb of blending. A lot of activities of adulteration of with cheaper oils have been happening. The study conducted by FASA is an indicator towards such a trend. If the blending, but this is the Delhi sample. If the blending is stopped for mustard oil, it will ensure that only 100% pure form of oil is legally produced. The adulteration with cheaper oils on the pretext of blending would be automatically guarded against. No allegation whatsoever against any manufacturer. I could not find any. Countries like then they go abroad, then they go to Europe. Countries like Italy and Spain, taking advantage of the provisions in the European Union regulations, have prohibited production of blended olive oil for their internal consumption if the provisions of WTO permit such an action to be taken by member states subject to SPS and TBT compliances. India may also consider addressing its concerns via mustard oil on similar lines and limit local production only to 100% pure form without any blending. The committee was unanimous on the issue that blending for edible oils is not bad, and the blending has its own set of advantages. However, considering the limited contribution of mustard oil to the overall quantum of blending oil, 15% out of 100%, having regard to the numbers, various types of oils cannot be termed as a very minimal quantity, as a minimal percentage. And its unique identity in the Indian context, the committee felt the need of putting in place specific regulations by FASI prohibiting blending in mustard oil and to facilitate manufacture and sale of pure mustard oil for domestic consumption. But this is what has happened. So now kindly take, my lord. Kindly take straight away.
No, the decision is something else. What the discussion is something else.
Yes.
Because the discussion
refers to adulteration and all that.
Correct.
And then finally it is all about, my lord, it is just like promoting, what should I say, promoting production of mustard oil.
Because the blending oil starts from 8.6.
8.6, yes.
13. So 8.6.
This is what triggered the entire action. First it was, the interministerial, it was decision taken by two ministries. One, Ministry of what is it? Health and Family Welfare, and Ministry of Agriculture, subject to correction. These two ministries came together and, my lord, formed a committee, interministerial committee or team, whatever it may be. This team filed this report. The annexures to this report your lordship has already got. Then, my lord, your lordship will find that the regulation, the order was passed, draft regulations were framed. The draft regulations were also provided to the scientific panel along with comments and suggestions so that scientific panel can make recommendations. There is a missing link which we could not trace. Well, kindly come to page 81, 82. I read two provisions from the Act. One, Section 13, three provisions. Section 13 is scientific panel. Section 14 is scientific committee.
Correct.
Section 15 is the procedure to be adopted by scientific panel and scientific committee. So, scientific panel is a distinct and separate entity if and when compared to scientific committee. So, having regard to that, kindly take, my lord, the consideration of agenda at page 82. The panel discussed the comments. I'm sorry, my lord. The panel discussed the comments received on draft notification from all stakeholders. The recommendation of panel along with justification are at Annexure 2. Since the matter relating to prohibition on use of mustard oil in blended edible vegetable oil is being monitored on priority by the government, so it is all as per the wish and command of the government. The process of finalization of the said amendment needs to happen before 5th of February. So it needs to happen before 5th of February 2021. The recommendations of the panel were approved by all members during the meeting so that it may be circulated electronically to what, my lord? Scientific Committee for Concurrence or Suggestions. So this panel, what happened, what had to happen thereafter must have happened. We do not have access to the scientific committee discussion or recommendations, whatever it may be. My lord, when first, my lord, a high part committee was constituted. Then, my lord, 2 meetings were held, one on 4th of July, another on 8th of July. Comments or suggestions were invited from expert bodies. Apart from a stray incident or one sample, I may use the expression the sample so far as Delhi is concerned, there was no data available so far as adulteration of mustard oil was concerned. Whatever adulteration has been complained of, it is with regard to adulteration of single sourced oil, which is mustard oil as such, not blended oil. Then, my lord, the committee made recommendations that stop blending of mustard oil or stop using mustard oil in Bevo. My lord, the immediate precipitative action which was taken was a order issued under section 16(5). Then, since writ petition was filed by the association in Delhi High Court, immediately, my lord, thereafter they withdrew the order. In the meantime, or immediately thereafter, they issued the draft regulations. The draft regulations invited objections. There were 467 or 468 in favor. Suggestions. Well, I will read those suggestions. They are very interesting. Then, my lord, there were 23, 24 who were on our side, including our association. So we were outnumbered. Naturally, we had to be outnumbered. So, my lord, then what happened? The scientific panel made recommendations. Those recommendations must go to the scientific committee, which we do not know, must have gone, because it's a governmental action. We would presume that it has been done so. But we do not have access to the decision of the scientific committee. Then, my lord, the subsequent steps are to be taken. That is finalization of the draft notification. Finalization of the draft notification took place in 2021. And, my lord, this was given effect from June 8, 2021. 8 June 2021. My lord, kindly take who were in favor, their remarks.
Okay, now stop here.
But do I come back on Wednesday, my lord?
I don't think so. How much time will it take?
Mala, I don't want to take, Mala, today, Mala, it was, Mala, I thought I could conclude. But today, Mala, I will not take more than, Mala, I try to be very economical. Mala, actually, I have a limited way of expression. So, Mala, I try to be economical. So, kindly keep it on any day, apart from, my lord, Monday and Tuesday. Monday and Tuesday are some difficult. Thursday, my lord has already fixed one matter. I have difficulty on Wednesday, Thursday. But, my lord, we want to get the matter because I tell you, lordship, this matter was substantially heard by Justice Bhattacharya.
My lord takes it up on 3rd February. Then.
February? Why?
Wait, double chuti hai 26 tarikh.
Well, let us do it on 27.
27 the first day I've already fixed. Please also.
Tumi kabe ascho? When are you coming there?
3rd February.
27, after that I'm fine.
If you're saying
28, my lord.
No, my lord, I have some difficulty on 28, 29. All fixed matters have been. My lord keeps it on 3rd February.
3rd February, they will khali.
Second, I'm here. Second, I'm here.
Second.
Second is not Sunday.
Second is Monday.
Second is Monday. That's a monthly lease day, in fact.
Second is fine.
2 baje?
তোর অসুবিধা না
আমি জানি না এখন কি হবে second is too far away na
Sure.
but can it be second fourth whichever day
2 baje nahi hai. Okay, 2nd February at 2 p.m.
কি করবে এখনই ঠিক করে না
মানে 4th February at 2 p.m.
4th February খালি আছে কি?
My lord will give me one session, I will complete.
and thereafter my lord will give me 1 week and I'll come.
Entire week. my lord, that will, my lord, generate a lot of oil.
What I meant was a week after.
और आगे क्या खाली है?
My
Fourth
lord,
के बाद?
fourth then, my lord, fourth.
Fourth के बाद? Just a minute. No, fourth के হবে না, fourth के बोले আছে बोले.
And my lord, we will also prepare notes for your lordship's kind consideration.
Counsel for the plaintiff.
Once, my lord, Mr. Kundolia and my learned friend consider.
But due to paucity of time, hearing
Who has already made half of his submission.
matter appear on 4th February.
I'm not that economical.
When?
Huh?
Last, then
Next
when it
year.
is? 4th is okay. Thereafter, when? At 2 p.m. as a specially fixed matter.
11. My lord, fourth, let me conclude on
Fourth I have fixed.
Yes,
At 2
fourth
p.m.
time. Fourth पे आशी आगे.
Okay. Lordship, next matter, item number 8, Lordship.
Grateful, my lord.
Urgent matter, tender matter, Lordship. I'm not traveling, Lordship, today, Lordship. Lordship, Monday, let it be in the same position.
আমি তো
And Lordship, what result is, Lordship, my learned friend has served directly to the party. Lordship, let me
Well, I take your lordship's kindly, my lord.
Started a government lead office, Lordship. Lordship, kindly pass it now, because my learned friend has, my junior has served it directly to the party. That is chief medical officer. Lordship, GP service has to be done. Lordship,
Third date. What? Not necessary for order. If they are not accepting, not accepting. Come on.
then Lordship, let it be remain the same.
Okay. Okay, origin side matter.
Lord, may I please mention, my lord, original side?
May I permitted to mention item number 160 of today's list, my lord. The matter may be released from your lordship list because due to lack of determination, my lord.
What is the matter?
My lord, matter is regarding surfacing, my lord.
Huh?
Matter is regarding surfacing.
Item number?
160.
You got an order. 160.
160. Yes, my lord.
160.
Yes, my lord.
Item number 160. Huh? Counsel for the petitioner submitted the matter is connected with the surface act.
Number 6.
Accordingly, for release of the matter. In view of the above, WPO number so is released from the list of this court with the liberty to the parties to mention the matter before the appropriate court having
WPO 6 of 160. Great.
My lord, minor correction, my lord, in a judgment, my lord, delivered by lordship. In a suit, my lord. Kindly see the last, my lord, entry. Page 8, my lord.
This is when this is a second correction.
Yes, my lord, only one remains. Kindly at the bottom, my lord, see. 15, my lord.
That is to be mentioned.
Number is to go in.
Please, my lord, may I mention item 94 of my lord's list for extension of the interim order, which is expiring on 21st of March, next Wednesday, my lord. My lord,
21st of March.
Oh, of January, my lord.
21st of January.
My lord,
उसका रखो 20 जनवरी को रखो. उसका 20 जनवरी को extension of interim order. Yes, call the list.
Item 1, Lordship, I appear for the respondent, Lordship. I was addressing your Lordship on the last occasion. This is with respect to the civil reporting by the Indian Bank, Lordship.
Yes.
Very briefly, what had been contended by my learned senior on the other occasion was that there was a settlement. According to them, they have complied with the settlement. Only the interest payment is overdue. However, bank has reported the same as a loss account. He has also submitted that the bank has classified the accounts as fraud. However, there was no, allegedly, or according to them, there was no, the procedure for fraud classification was not followed. My lordship, as I had previously submitted, that the 3 circulars, one is the civil reporting, most respectfully, lordship, is not even under a circular. There is a separate act for that, and there are subsequent guidelines. Lordship, I have already filed with your lordship's court the concerned Act, the Credit Information Companies Regulation Act, and I have also filed one master circular dated 6th of January 2025. So these, Lordship, most respectfully, as there is a specific act for the credit information reporting, and there are guidelines pursuant to the power conferred by the act. There are the guidelines which are issued by the RBI.
Yes.
Fraud classification is a completely different aspect, which is on a master circular. A willful defaulter classification is also on a master circular. So the three are completely distinct and there is no overlapping. However, the fact of fraud, which has been mentioned in the settlement compromise letter, was never challenged by the petitioners at any point of time. That is my submission, Lordship. There was a fraud classification. That I will come back later because that really does not concern this subject matter. This is under the specific act.
So whether the
Lordship.
bank has
Yes.
declared as a fraud or a loss account?
Lordship, bank has reported it as a fraud as back as in 2015. Fraud reporting, Lordship knows, is done by the bank to the RBI. Thereafter, RBI causes the publication or whatever. That was done 2015. Prior to all this procedural formalities regarding the fraud, the master circular came into effect. That was done in 2015. They were communicated by way of that settlement letter that your account is already fraud, and by way of the compromise, we do not compromise on any of the criminal aspects of the charges leveled against you. So, and that was never in any proceedings whatsoever challenged. What was challenged was the classification, the identification of the petitioners as willful defaulters was challenged by the identification committee, was challenged before this honorable court. The learned single judge had upheld the order of the identification committee and given liberty that you approach the review committee. That order was assailed in appeal before the honorable division bench. The honorable division bench made certain arrangements for the subject matter of hearing that specific appeal. There were certain directions given for payment, according to which the honorable court held that there was no incidence of any willful default. That cannot be said. However, the bank was granted a liberty to proceed under the master circular, which the bank, as per my instruction, has not further proceeded for willful defaulter classification. Now, Lordship, three things I will indicate from my report first. Lordship will kindly have my report.
Yes.
Yes. Lordship, as I had indicated, firstly, that there are pending proceedings against the petitioners. There are investigations by the CBI.
Yes.
Is evident from the annexure A1, Lordship, that starts from page 14.
That's the FIR.
Yes, the FIR. Lordship, this is and investigation is pending with respect to the petitioners, and Lordship has I had indicated that the name of the petitioners are appearing. The petitioner number 2 is also expressly appearing as one of the accused persons, accused number 2. Lordship, this I have indicated. Lordship, then Lordship will kindly take up the settlement proposal letter once. The compromise of 2015, Lordship, it is at annexure A2.
Yes.
Lordship. Lordship will kindly take up paragraph 5 of the terms of other terms of the compromise approval. It says that if you fail to honor any of the above referred terms and conditions, then compromise approved by the bank will automatically stand cancelled and withdrawn, and all the concessions and relief granted in this settlement will be treated as withdrawn. The bank will have the liberty to proceed for recovery of the entire outstanding dues with interest, costs, and expenses as if there was no compromise settlement. Lordship, admittedly, as also from the order of the Honorable Division Bench, it will be evident that that compromise was not adhered to by the petitioners, Lordship. The non-compromise there was a letter, that is a subsequent letter at A3, Lordship. This is the in 2016, which will show that the bank has communicated that there was non-compliance. Thereafter, what is important is, Lordship will kindly come to annexure A4 at page 27. From this, Lordship, what is evident that even after it is there, the petitioners have approached the bank for compromise settlement, even subsequent. Also, the last one I had shown, that was in June 2025. I had shown an email on the last occasion, which I will place once again. Refer to your OTS offer dated 13 to 2019 and 28 to 2019. This implies that even they understand that there is no compromise as on date.
Yes.
We have to advise that the competent authority has not accepted your revised OTS offer of 50%. And in this regard, we have earlier advised you to improve your offer substantially. VDR letter dated this and this. Thereafter, your offer for revise of OTS was rejected as not acceptable to the competent authority and conveyed to you to stick to the terms and conditions of repayment of existing OTS sanctioned in white letter. This is this and this. This is, we asked them again in 2019 to follow this settlement terms, which was again not done, which I will also again indicate, Lordship. This, even according to them, there was no OTS as on that date, but the bank says that you kindly follow this terms of the OTS settlement of that and that, this and this. And what we also do is, there is a accept a payment of 1,50,00,000. We did 3 checks run on this, and we also keep it in the account which was created for the purpose of the OTS settlement, Lordship. Thereafter, Lordship will kindly come to the, again, Lordship will kindly come to the subsequent annexure, that is at page 28. Again, we refer to this letter of their letter in respect of opening of current account and allowing unlimited transaction in the account. In this regard, we have to advise that our head office has not agreed to your proposal unless and until settlement plan for entire credit facilities availed by your associate or group of companies, family members or promoters which stand NPA with us since long and sanctioned compromise proposal has also failed in all the accounts. We advise you to repay the remaining OTS amount with interest at the earliest. Lordship, once again, an opportunity is granted to them to consider the repayment of the OTS. Now, Lordship, thereafter, there is one annexure that is at page 29. This, Lordship, is in respect of 2 loan accounts, that is Shantati Enterprise and Siddharth Kejriwal, wherein the petitioner number 2, Lordship, will find his name appearing in the left-hand side corner, Lordship. There was again a settlement offer with respect to these 2 accounts, which also did not stand complied. Lordship, from the annexure which is appearing at, Lordship, at page 38, Lordship will kindly find that on 27/6/2025,
page
this 38. Lordship has in the last letter found that these are the 2 loan accounts, that is this Shantilal,
correct, yes,
yes, and Siddharth Kejriwal. These were the 2 loan accounts we had referred to in this compromise letter. Even these compromises were not adhered to, and Lordship will kindly look into their email, which is addressed to the bank, to the head office of the bank, and where he says that I am writing with reference to non-performing accounts under the following 4 account numbers. Now, Lordship will kindly consider that the first 2 account numbers are in respect of Kejriwal Mining Private Limited itself, which is the petitioner number 1 before your Lordship.
yes,
And the other 2 are regarding the other 2 accounts for which also the bank had sanctioned a compromise, which was also not adhered to. So he says, since the beginning, first there is an admission that these are non-performing accounts. He admits, I'm writing with reference to non-performing accounts under the following 4 account numbers. So there is an admission that these are non-performing accounts. Since the beginning, I have been consistently trying to settle the accounts amicably and in good faith. Despite my sincere efforts, certain formalities and procedural issues have remained unresolved, We had earlier interacted with this and this of the bank regarding the matter, and based on those discussions, I now wish to take it forward to its logical conclusion. So even in June 2025, he writes this letter where he acknowledges that these accounts are live accounts with the bank and live NPA accounts with the bank. So Lordship will kindly see that what is the history, what is the conduct of the petitioners who are before your Lordship, and who apparently praise that the credit reporting has been erroneous, where admittedly we say on affidavit before your Lordship that today we get an amount of around 72 crore 16,29,585. The details of the claims, Lordship, that is at paragraph 22, Lordship. The details of the
page
11 of my report. Report.
Yes.
Yes, and also Lordship will find it in the tabular form, which was also communicated to the petitioners before they had filed this writ petition. That is annexure at page 32. Lordship will find that there is a letter dated 14/8/2025. This was a composite letter which was served by email as well as by physical copy. Lordship, this is annexure A7.
Yes.
Starts from page 31 because it was an attachment to the email also sent. And page 32 is a copy of the letter. Here, Lordship, the bank has categorically stated what are the natures of the default. Page 34 in tabular form states that these are the dues of the bank. So this was well within the knowledge of the petitioners, and the petitioner knows that the accounts are live NPA accounts before your Lordship. Now, Lordship, under the Act, what is our obligation? Lordship, I have handed over the copy of the Act as well as the circular. Lordship, the Act is the Credit Information Companies Regulation Act 2005.
Yes.
Yes. Lordship has got the definition clause, Lordship. Now, credit information, Lordship, there is a credit information, that is a definition 2D.
Yes.
Yes. Credit information means information relating to the amounts and the nature of loans or advances, amount outstanding under credit cards, and other credit facilities granted or to be granted by a credit institution to any borrower, the nature of security taken or proposed to be taken by a credit institution from any borrower for credit facilities granted or proposed to be granted to him, the guarantee furnished or any other non-fund-based facility granted or proposed to be granted by a credit institution for any of his borrowers, the credit worthiness of any borrower of a credit institution, and 5 is any other matter which the Reserve Bank may consider necessary for inclusion in the credit information to be collected and maintained by credit companies and specified by notification in this behalf. I will come back to the notification, Lordship. Lordship, but before that, I will just place that the objective of the Act. The objective of the Act is to provide for regulation of credit information companies and facilitate efficient distribution of credit and for matters connected therewith or incidental thereto. So this is simpliciter in respect of a credit
information.
Yes, credit information that. And now Lordship will kindly in respect of this credit information, Lordship will kindly take up the circular ones and come to page 11 of the circular, Lordship.
2025.
Yes,
The same.
6 January 6, 2025.
Okay. Clause.
Lordship will come to clause 9, that is at page 11.
Yes. Credit information.
Yes, this is the credit information report. What it needs to capture is indicated. I will come that what is my obligation in reporting. Lordship, I will directly come. The first two I will not place. These are third. CIC shall capture details of co-borrowers and guarantors wherever applicable in the CIR. This would facilitate deciding on the extent of exposure a CI can consider on an entity. The CIR shall give details of the loan availed by customers in their capacity as borrower, co-borrower, guarantor. So in all respects, the CIC is required to capture this information. Now, in case of multiple borrowings by the same customer involving both current and closed accounts, Lordship will kindly mark that CIC shall provide information on various accounts in order of live accounts, closed accounts, and overall position of NPA status, willful default, suit filed, with limits and liabilities for each account.
Yes.
So, the contention that the bank is wrong in providing the information with respect to all the connected loan accounts where the petitioner, especially the petitioner number 2, is also the director of those companies and co-borrower or guarantor in respect of this loan accounts, Lordship can find that it is obligatory that the CIC records all the credit information. Basically, it is the credit history of a person to assess whether or how much credit can be given or advanced to that person or entity. Now, Lordship will kindly come to page 60.
60.
60. This is the guideline for reporting the credit information in the UCRF. That is the Uniform Credit Reporting Format.
Correct.
Yes. Lordship has found that.
Yes.
While reporting credit information to CICs in the Uniform Credit Reporting Format, CIs and CICs shall adhere to the following guidelines. In commercial reporting segment, corporate identification number and credit history, Lordship will kindly mark, of the directors of the company based on DIN number shall be reported to CICs or CIs by CIs to CICs and included by the CICs in their report. CIs shall report cases where compromise settlements have taken place and the reason for such compromise settlement in the prescribed data formats to the CICs. With respect to part installment overdue, the CIs shall submit data as it is, while qualitative information on what filters to apply based on the amount and period would be done by the SU and others who make use of the data. The CIs shall use settled status for denoting only specific situations where, due to financial inability to repay as per original terms and conditions, either a principal or an interest waiver or both is provided to the customer. CIs need to be aware of such a situation prior to extending fresh credit to customers. Cases of wrong debits or contested charges
So
shall
these
be...
are the procedures.
These are my obligations,
Correct.
Lordship. These are my obligations that I have to report with respect to a live account, a closed account, with respect to directors, with respect to connected loan accounts.
Correct.
The credit history of an entity will be a composite history, not a standalone. Now, Lordship, with respect to that, today, they have approached your Lordship stating that this loss classification by the CIC be removed. Firstly, we have a particular format which is prescribed by the guidelines to do the reporting. The CIC, that is the Credit Information Company, prepares the final credit information report, compiling whatever has been received from the several financiers. Now, with respect to, if there is a dispute, Lordship, this with
No,
respect
after this guidelines is followed, what will happen?
Lordship, we will have to do the reporting
Correct.
of whatever information is available with us.
Correct.
That information will be coming from respect to, of all the financial
yes.
institutions or banks, whoever has given an advance.
Correct.
CIC will compile that data, and he is the credit information company who maintains. Credit information company is also party to the present proceeding, Lordship. All that I am saying as the information providing bank or the CI is that I am under an obligation to provide the information which is standing with my bank as on date. That is an obligation created by a statute, not also by any circular. I am under obligation
As per these guidelines, you are an obligation to submit the
to submit, and with respect, because one submission has come to your lordship repetitively, is that there are connected accounts which have been clubbed. So all I'm trying to substantiate is that lordship, under the guidelines, what is to be furnished by a CI is the composite data with respect to any of the entities which is available to us. All the composite data has to be given, including the data of the directors, if in case of a company. So since here lordship finds that this Mahesh Kejriwal is a party to the other proceedings, all the data has to be supplied. Sorry, not party to the proceedings, is a borrower or
party, yes,
other loan accounts. He's got an exposure, so we are under an obligation to inform the entire. And with respect to Kejriwal mining itself, lordship, we say that as on date, this is what we get from you, because you never adhered or complied with the compromise settlement either in 2015 or even after subsequent opportunities being given to you. You have not paid what was ideally due for you to be paid. Now, today, lordship, most respectfully, according to this, the act, the information when there is a dispute with respect to, I say I get 10 rupees, he says no, you don't get 10 rupees, you get 2 rupees. This can be a dispute, lordship. It is not disputed that the accounts are still live, because I have shown your lordship that there is an email today. Lordship will kindly take up the act once again.
Yes.
Lordship will kindly find that there is a provision in section 21 for alteration of credit information files and credit reports. The act is otherwise also provides a mechanism that I will show, lordship. There is a mechanism for arbitration provided in the act itself.
Yes.
But lordship, first, there is a scope that a person can apply for correction of his or alteration of his credit reports. Now, any person who applies for grant or sanction of credit facility from any credit institution may request to such institution to furnish him a copy of credit information. That is not relevant, lordship. On request furnish, if a, lordship, I'll come to 3 directly. If a credit information company or specified user or credit institution is in possession or control of the credit information, has not updated the information maintained by it, a borrower or client may request all or any of them to update the information, whether by making an appropriate correction or in addition otherwise. And on such request, the credit information company or the specified user or the credit institution, as the case may be, shall take appropriate steps to update the credit information within 30 days after being requested to do so, provided that the credit information company and specified user shall make correction, deletion or addition in the credit information only after such correction, deletion or addition has been certified as correct by the concerned credit institution. Now, this provision proviso will be very relevant, lordship, provided further that no such correction, deletion or addition shall be made in the credit information if any dispute relating to such correction, deletion or addition is pending before any arbitrator or tribunal or court, and in cases where such dispute is pending, the entries in the book of the concerned credit institution shall be taken into account for the purpose of credit information. Lordship, what I want to emphasize, lordship, is that today if they dispute it, since I am a bank maintaining records, according to the statute, that is my being the credit institution, my accounts will be taken into account for the purpose of the credit information. Now, lordship, here I will also indicate, because I am under an obligation to do so, that even this act provides for a mechanism for settlement of dispute. If there is, First, they can apply for any alteration.
No, you are
Yes.
this provided that no such correction, deletion,
Yes.
addition. So what is why you are mentioning this? Why you are
Entries in the books, Lordship, the last line I
Correct.
want to, shall be taken into account for the purpose of the credit information.
correct?
So, Lordship, this most respectfully, that my books of accounts will be, when I say that I get a certain amount, this information has to be taken into account before considering the matter any further, whether by the tribunal, court, or the arbitrator.
No such correction, deletion, or addition
Yes.
shall be made in the credit information if any dispute relating to correction.
Concerned credit institutions shall be taken into account for the purpose of the credit information. Now, what I say is that, Lordship, I will come. Why I place this is that today I say there is a certain amount which is outstanding in the books of the petitioners. Now, this outstanding amount cannot be either this has to be adjudicated on evidence, because today before and even if before and learned arbitrator or tribunal or before your lordships, my claim has to be looked into and considered by the honorable court. So today I say that this makes it a disputed question of fact which your lordship sitting in the writ jurisdiction possibly cannot enter into.
Correct.
So I say that today there is an outstanding of this amount which actually makes the account of the petitioners as a loss account, because the NPA have dated back to much prior to 2015 and ahead of time. I do not remember the exact date, it is there. And today also there is no repayment which has come to the bank. So in the books of the bank, this amount is shown as outstanding, which is to be considered. And today when I show that there is no dispute, they do not, from the records I have been able to establish that even they admit that there is an outstanding amount in respect of all the 3 accounts, or rather 4 accounts. Kejriwal Mining has 2 accounts. So this is a dispute. The dispute may be whether what is being payable or what is the amount payable. In this lordship's jurisdiction, lordship cannot enter into the merit of whether the credit record report or the credit information I have furnished, I am required to correct it as per their terms, is what I just set to place on that. Now, lordship, which I also need to indicate before your lordship is that
Yes.
civil to nahi. Actually, one of the part, the civil is not there. The RBI is also not there.
I appear for civil, your lordship. I am appearing for civil, my lord.
Well, let civil reply, let RBI reply.
So I will just
Civil has given the walkover to you.
The difficulty is, it is civil's entry that I am challenging. Today, my learned friend is arguing civil's case.
No,
Your lordship, I have only a brief submission in this matter.
I asked
my lord.
myself one. I have heard my learned friend.
take
My answer is very simple. Today, your lordship has seen, so far as Kejriwal Mining is concerned, the account is settled so far as principal is concerned. The order records that there is an offer to make payment of an interest amount of 1 crore 46, which they have not accepted. Now, the rest of the amount is lying in dispute. So my learned friend's contention is, when I am disputing what is due to me and the court is looking into it and adjudicating the matter, I shall make a reporting and your civil score will go to the dogs.
No.
But is that possible? In a free economy like ours?
Respectfully, that is not my submission. I do not know that how this is being said.
Anyway, let her complete. Let's, because RBI and civil
This is no problem. Let me come then only I will need.
Your lordship, after bank finishes submission, my lord, I have just brief submission. I appear for civil, my lord. I have just 2 sentences of submission, my lord, in this matter.
Civil is watching, sitting inside the window.
I tender my apology, my lord. I could not be present physically, my lord.
My lord, may
Okay.
I have your lordship leave, my lord? Another matter is going on. I shall come back, my lord, whenever your lordship wants me.
Yes.
Lordship, exactly apprehending what my learned senior had just submitted, Lordship, is what I feel, that the Act provides a mechanism for settlement of dispute because it is.
They are on the settlement.
Lordship, yes.
They are on the settlement.
They are on the settlement, but there is no settlement, is what I say on record. I have said that on record, and the record is speaking.
So they are on the
volume.
settlement. They are on the settlement. You are saying that no settlement provisions is there. You have informed that, but they have not come forward for regularize their.
Absolutely.
That is your, and so that's why, and you cannot. And it is your bonded duty to make the report in terms of the act. You have made
Yes,
the
and
report.
today's date we say that we get this X amount from you because you have not adhered, and we do not need to give you an express. We have extended the time for even payment in 2019. You did not come up to the bank or clarified your cleared your debts. Even there is a subsequent to accounts where we have given you a compromise, but even there you did not adhere to that. Then we are under a bounden duty. Now, Lordship will just kindly, very cursory glance, Lordship, there is a provision for arbitration in the Act itself, that is at section 18. Because possibly it is understood that if disputes of this nature crop up, then possibly this will involve the leading of evidence. Because the Honorable now, my learned senior just once again mentioned the Honorable Division Bench judgment. I will have to now place it and distinguish it a little, because there the Honorable Court did not say that no, the settlement is binding on you. For the purpose of the willful default of classification, that settlement was looked into, because that was also extended for a certain period of time in 2019. Their lordships felt that willful default will involve an intention of not repaying, and that is why if you make this temporary arrangements, their lordships made some temporary arrangements for the bank to get some money and for the petitioners to come out of this willful defaulter identification, which was done.
Okay.
Now, Lordship, very briefly, Lordship, one more aspect which I need to cover is, which also I will cover very briefly, because these are not primary. What I'm trying to say that this fraud, because on the last occasion.
With regard what the arbitration set 18.
Yes, 18, Lordship. This provides
If any dispute
Yes.
occurs among the credit information company.
borrowers and clients on matters of business credit information. This provides for a mechanism for arbitration only on appreciation of situations where the legislature in their had the idea that it would require appreciation of evidence.
No.
Because, yes.
Shall be settled by conciliation and arbitration
Yes.
as provided in the Arbitration Cancellation Act, as if the parties to the dispute have consented in writing for determination of such dispute by conciliation or arbitration by the as if
As if the parties to the dispute, because arbitration otherwise requires an agreement. So here it says that
Section 89 of
yes, so section 18 says as if the parties had agreed for arbitration.
Okay.
So the fact that this would require appreciation of evidence is evident from the fact that a mechanism is provided in the Act itself. Today, lordships are troubled with so many flawed classification matters and so many willful defaulter classification matters because the mechanism is silent on all those, completely silent. But this, I most respectfully say that this procedure of the bank is absolutely mandatory under a statute. And the statute also provides two redressal mechanisms, one under 21, where there is an opportunity for correction, praying for alteration of the records, alteration not done, then it should be treated as if you have signed an arbitration agreement. So there is a clause for arbitration because this will require appreciation of evidence. The Honorable Court, most respectfully sitting in this determination, cannot direct the bank as to how to report the report to the CIC. The CIs are obliged to report history of all connected accounts, borrowers, co-borrowers, directors, everybody. Now, Lordship, one brief submission which I will make because this has been come to your lordship and because there might be a confusion which has been created, lordship, I again say that fraud is different, but with respect to one letter which has been relied on, that is appearing at page P3, at page 30, lordship, page 30 of the writ petition, lordship, they have said that their title deed has been held to be genuine by your empaneled advocate, and that is certified by the bank. Lordship, what has happened in this matter is that the dispute is not that the deed was not genuine. What happened in this matter is duly recorded in my report as well, lordship, in detail, and also in the letter which the bank had replied to the borrowers. What had happened was there was an Allahabad bank and an Indian bank, lordship knows, prior to the merger. Now, with the Indian bank, they had deposited one title deed. The father of Mr. Kejriwal, Mahesh Kejriwal, had deposited and created charge with respect to one of the immovable properties. Later, before the Allahabad bank, what they did was this: his father, there was a newspaper publication done that the deed is missing. On the strength of that, and thereafter he made a transfer deed to his son, Mr. Mahesh Kejriwal, lordship. This I will place the relevant paragraphs, I'll indicate. So, and he published that the original mother deed was missing. So the deed which he made to his son is not ingenuine. That was a genuine deed. That is why this certification is there, that the deed, but that deed was done during the subsistence of mortgage with respect to that property by the father with the Indian bank. Later, when these banks merge, it came to the knowledge and notice of the bank that this fraud has been, or maybe even prior to that.
Then page 29,
yes,
clause 9, the
yes,
fake title deed of
lordship,
the property.
the fake, why it has been stated to be as fake is that this title deed was, it is not the title deed per se. I will say that the language, lordship knows that the language of the authorities is not like technical as the courts or the advocates. It is the title deed was not fake. As per my instruction, lordship, the title deed was not fake, but the deed was executed during subsistence of a mortgage, knowing very well that that immovable property is already mortgaged with the bank, lordship. So that submission, lordship, is there, that those paragraphs, lordship, are
So, I mean to say it is not fake.
Yes, I say, but lordship, what I, above all, what I want to say is that these directly have less correlation to the factum of whether it is a fraud account or not. That fraud, first thing, was never challenged. Second, in this proceedings, clubbing up the particular statute, lordship will kindly take up these are there, the averments are there in paragraphs.
Your report, your affidavit.
No, yes, Lord, the letter at page 32, it starts from page 32.
32 of?
Paragraph 6 at page 34.
32 of your report.
Yes, lordship, my report. The bank had stated why they have mentioned that. Subsequently, that account has been settled. So today's date, maybe it is not a fraudulent deed or fake deed. Lordship will kindly take up paragraph 6, may I please, at page 34. This is a reply letter. Lordship, this reply letter had mentioned in detail why there cannot be a correction done on the end of the bank. This was not made a part of the writ petition.
Yes.
Paragraph 6, the bank records further reveal that original title deed this and this in the name of Shubhra Trading Company was mortgaged to Indian Bank in the loan account of Shubhra Exports, Murari Mohan Agarwal and Scrap, inter alia by Murari Mohan Kejriwal, father of Mr. Mahesh Kejriwal. But despite of such facts, the father of Sri Mahesh Kumar Kejriwal, being the major stakeholders of MS Shubhra Trading Company, executed a sale deed in favor of Sri Mahesh Kumar Kejriwal, with a sale deed this and this on this and this, and accordingly the said property was mortgaged to the erstwhile Allahabad Bank in the loan account of Parijat Vapar, now Kejriwal Mining. This further brought to a notice from a records that above Sri Murari Mohan Kanjilal had lost a GDR with the Air Street police station and also made paper publication regarding loss of aforesaid title deed being this and this, knowing fully well that the said deed is deposited with Indian Bank and what the subject matter of OA number this and this filed by Indian Bank against Shubhra Exports and others, Murari Mohan Agarwal and others, and this and this. And the conduct shows that Sri Murari Mohan Kejriwal and Mahesh Kumar Kejriwal, in collusion with each other, purposely done the aforesaid acts with malafide intent to defraud the bank. It is a matter of record that loans granted by Indian Bank to Shubhra Exports and this were outstanding on the date of execution of the sale deed this and this by Murari Mohan Agarwal alias Murari Mohan Kejriwal in favor of Mahesh Kumar Kejriwal. The bank records further reveal that FIR has also been lodged by the bank against Mahesh Kumar Kejriwal, Mrs. Alka Kejriwal and Siddharth Kejriwal in view of the fact that the overdraft limits were obtained by borrowers by marking lien on LIC policies. And out of 36 policies, 13 were found to be cancelled by the LIC as the checks were issued by borrowers towards payment of initial premium were dishonest. The bank records further reveal that Mahesh Kumar Kejriwal and others previously made OTS proposal for settlement of loan dues in respects of loan accounts, that is Kejriwal Mining, Siddharth Kejriwal account and Pioneer Butter, but failed to adhere to the terms of sanction and the said loans are still unpaid. Now it refers to the circular and penal measures otherwise. So Lordship, this letter, Lordship, is what we rely on, and we say that we had a prayer was made for alteration or correction. We have adequately replied to this. Now, most respectfully, Lordship, today what I have placed before your Lordship is that there is an outstanding. I am under.
Who has made the complaint to the CBI, the investigation bank, Allahabad Bank?
All the complaints are by the bank. Because this Lordship, the history Lordship can see that what is outstanding as on date. And now they come before your Lordships and state that no, my credit report has to be corrected. Because credit report is what is looked into while paying. And I most respectfully submit once again to conclude my submission that I'm under an obligation, closed accounts, present accounts, settled accounts. And this is not only with respect to this particular petitioner. A credit history, as I have said, is available for all of us possibly. All of us who are availing loans, we have a credit history. And
now what is the situation of the account lying idle?
It's not repaying. They're not repaying. They're filing litigations.
That
bank is defending litigations, and they're making some paper proposals that we want to settle. And I have enclosed that email where they are aware, Lordship. It is not a fact that they're not aware. And there are again interstate disputes between the Kejriwals. Lordship, I believe there is an application. Even Lordship looks into that application. I had the occasion, because Lordship has not yet allowed that application. I cannot place reliance on that. But even that application speaks volume of the conduct.
Okay. That's all.
Yeah. I do not need to trouble your Lordship with judgments on appreciating evidence sitting in the street court. So I'm not placing anything otherwise.
Yes, civil. Very
Yes,
civil.
Your Lordship. Yes, Your Lordship. I have just two submissions, Your Lordship. In the present writ petition, 2 accounts in respect of Kejriwal Mining is the subject matter, my lord. During pendency of this writ petition, CIBIL issued an email seeking confirmation from the bank that whether this loan account which has been reported as loss, still you are confirming that status. Bank has not disputed such status. Now, CIBIL as an authority, just to report, we proceed on the basis of the whatever information which is received and confirmed by any bank or financial institution, my lord. So, I suo moto cannot make any addition, alteration or any changes. The bank has not disputed. Even during pendency of this mail also, the bank has not sought to change any status of the petitioner, my lord. So that's why this reporting is done, and as CIBIL suo moto cannot do, my lord, which my learned friend has also placed the proviso to section 21, my lord. Every alteration, modification or change has to be confirmed by the bank or member institution, my lord. Without they confirming any changes, nothing can be done on the part of CIBIL, my lord. So that is my respectful submission, my lord. Unless the bank request for changing of the status from loss to something else, my lord, we cannot make any changes at our end.
Yes.
Seeing it is loss. So much of money we get from the bank. I mean, from the petition.
Okay. That's all.
Yes, my lord, that's all.
কি করবে জিষ্ণুদা বলবেন আমি বলবো বলে দাও তাহলে কবে 28 না but Mr. Shah will give a detailed reply. Only what I understand from them, Madam, they may say that they have acted in terms of the Civil Act and the circular, their obligation on their part to report everything. Number one. Number two, that circular also is the obligation, director, guarantor, sorry, not the director, guarantor, co-borrowers, all reporting should be done. So they have acted in terms of the circular. Now, we are on the point, the reporting of loss. The CIBIL, which is under challenge, this is only with regard to the company. This CIBIL, Lordship will find that this CIBIL does not reflect the CIBIL of the co-borrowers, the guarantors.
Who are you?
I am the company. I am the company. So my CIBIL is which is there before the court. My CIBIL does not reflect the co-borrower CIBIL or the guarantor CIBIL. There is no connection or independent. Even the CIBIL, that section 2D of the Civil Act, it also records, my lord, of a customer. That if I just read it, the amounts and the nature of loans and advances outstanding under the institutions and credit limits granted by the institution to any borrower.
Correct.
So here the petition number 1 is a borrower.
Correct.
Now, so my CIBIL does not reflect the other informations, but only thing they are reporting the figure. They are bound to report everything. Now, what they are reporting? They are reporting two things. One is the amount due, and the other is loss. The amount due, which they are making submissions today, 10 crore or whatever the figures are, those are not reported in CIBIL. The amount which is
I don't think the amount is required to be reported.
yes, madam. The amount is reported. The outstanding amount is mentioned over there. The outstanding mentioned is only 1 rupee. I have a bank statement. I will show that also.
Yes, Mr.
Yes, Mr. Gap. And the other one is 5,000 odd, which I'm entitled to get back from them. So the amount which is shown in the CIBIL is minuscule, not those crores of amount. In addition, what they are showing is loss. Now, submissions has been made with regard to the obligations under the 2025 guidelines of reporting. Now, what is not submitted, Malad, is how do you classify under the Reserve Bank guidelines, how do you classify loss? So that is not submitted. Now, for loss classification, this loss is reported, Mr. Shah has indicated in the CIBIL's report only in August 2022. The reporting was done. So we have to look into the circular which was prevalent in August 2022 for reporting loss. That is important today, Marat. Now they how could have reported loss. Now this circular which was prevalent in that point of time was a circular of 2014. Right? No, 2012. The circular of 2012, Marat. So this 2012 circular was the circular which was prevalent in the year 2022 when they reported loss for the first time. Now, Malad, I just place this. I will not conclude today because Mr. Shah will conclude, but I just place this circular and for today, Malad. C3, sorry. 3, Malad. This is Lordship will see in the first, I must indicate, Malad, in the top, Malad.
Come to 3.2.4.
Yes, the first is master circular, income recognition, asset classification.
3?
No, I was on the first page. On the dated 2nd of July 2012, this is a master circular of asset classification.
Yes.
Now, after this index portion, Malad, we come to 3.
You will conclude today, no?
No.
Then
I just,
come on the next.
I just placed this, the asset classification.
Come on the
Yes, ma'am. বলে জানি শুনেছি.
And counsel for the bank has concluded her argument.
Lordship, only one thing, may I I skip my mind, Lordship will
Well,
kindly, only one thing, that with respect to that figures, Lordship had.
1 and 5,000.
Lordship will note that it is disputed by the entities written there. Only that thing. That is there. They had also placed that on the last.
Counsel for the respondent bank concluded, respondent bank and CIBIL.
The figures
CIBAN
disputed by
have
entities.
concluded their argument. Full stop. Due to paucity of time, counsel for the petitioner could not reply them at replying the same. Accordingly, case adjourned. Let the matter.
Data asset classification is that.
22nd January at 3 p.m. 22nd. 22nd January at 3 p.m.
28th হবে না
22nd January 3 p.m.
তাহলে মার্চে বাবা মানে 28th will it be anyway possible for my 28th Mr. Shah 20 কোনো চান্স নেই
Then you will go to March.
that is will be difficult for কি করবে বলো থাক 22 তারিখ থাক
Why? What has happened?
20th 21-22 জিষ্ণুদা নেই by some adjournment taken well, so we get a chance. Let it be on. Let it be on. 27.
Okay.
And Kushita.